of my lords, justices of appellate courts, heads of courts, judges of various courts with us, policymakers at both the federal and state levels, members of the National Assembly, respected members of the inner bar and the outer bar, and the general public. The reason for this summit is quite obvious from the title of the summit, and the array of speakers also speak to what we intend to achieve from the summit. I would not want to preempt the speakers, but I'm sure that at the end of this event, we will have a clear picture of what we're trying to drive at, the kind of conversations that we're trying to the kind of conversations we're trying to encourage in building lasting institutions, particularly judicial institutions. So I'll just go straight, we'll just dive straight into the event, and I'll invite Professor Fidelis Ojita, household name in the legal profession, both Queen's Counsel and Senior Advocate of Nigeria, first-class material, graduate from the Nigerian Law School and the University of Lagos. He's been visiting professor at the University of Oxford for quite a couple of years, and is going to be the lead speaker. We expect the Vice President of the Federal Republic of Nigeria to join us in just a few minutes. But Professor Fidelis Ojita, you have the floor to give us the lead presentation.
Good morning, ladies and gentlemen. It's a great honor and privilege to be invited to speak on the very important topic of developing an institutional concept of justice in Nigeria. And I must begin by thanking Wale Olanipeku and Co. and his partners for the initiative in putting this together, and secondly, for the efforts which I know these sorts of enterprises require. The timing could not be more appropriate. As a nation, our justice administration was already far from ideal. It was very seriously challenged in various ways. The COVID-19 pandemic has merely exacerbated the problems which we all know have afflicted the justice administration system in Nigeria. As we all know, of course, we're part of the global market for investments and for legal services, and the extent to which the country can attract business and investors will depend in part upon the quality of our civil and criminal justice system. If our system is perceived to be inefficient and ineffective, we would lose investment and capital to more efficient systems. And like many developing countries, Nigeria needs a strong, independent, and effective judiciary to trade itself out of its current poverty and to raise its people into prosperity. If we can promote Nigeria as a center of excellence in legal services, and as an acceptable, if not the preferred venue for the resolution of domestic and international disputes, the result would obviously be an increase in foreign direct investments into Nigeria and an increase in the amount of international legal business, which as lawyers, many of us will do. Against that background, I would like to highlight what I regard as a universal concept and determinants of an effective and desirable system for the administration of civil and criminal justice, which the users of court services and other stakeholders would have confidence in, and which they would feel satisfied at the end of adjudication, regardless of the outcome. It is not a coincidence that English common law and the English courts have remained dominant in shaping both the development of a common law as well as the resolution of international commercial disputes. Most users of English legal system and the English courts come out and feel that they've had a good experience, even if they did not win their cases. At the end of the day, no system of justice administration is perfect or can be perfect. But many are good or satisfactory. And good civil and criminal justice systems do not fall from trees. They are not delivered by angels, such as Angel Gabriel. They are the result of deliberate choices made and implemented by different countries. Such good justice administration systems, like other good things, do not occur by fiat or impulse, but they are the result of bringing together many small things. It is those small things that make a court experience worthwhile, and it is those small things that I would like to draw attention to. In my view, there are about 10 small things which make for a good justice administration system, and which, if localized in any system, would ensure that that system is fit for purpose. I'm sure others might disagree. They might say there are 3 or 4 or 20, but I've selected 10, which I think are perhaps enough to illustrate the nature of a challenge. In my view, the first is the existence of a rule of law. A rule of law, of course, is a fundamental and overarching concept, which requires that the law is supreme, that all persons are equal before the law, and they are accountable to the law, and that there is protection of human property rights as well as contracts. Just as economies are underpinned by trade, so trade itself is underpinned by the fabric of law and the civil justice system. The law provides a basic structure within which commerce and industry operates. It safeguards the rights of individuals, regulates their dealings with others, and the steady neglect of the rule of law in many developing countries has been a major reason for the decline in the development prospects of such countries. So that's the first, what I call universal concept that I'd like to draw attention to. The second is the quality of institutional capacity. By these, I mean the quality of the judges, the court registries, the court staff, and the court infrastructure, including the court buildings themselves. This is self-evident. How judges are appointed and promoted is important. Appointment and promotion must be by merit and not by quota or other irrelevant considerations. Judges must be competent, knowledgeable, and courteous. They must have integrity and insulate themselves from political, economic, and social pressures. Courts must be adequately funded so that they are able to operate efficiently, and court registries, which are the engine room, must be fit for purpose. We know that the senior registrars are like the chief operating officers of courts. Only competent, dedicated, courteous, and honest persons should staff our courts and our court registries. The third universal concept, in my view, is the predictability of court decisions. Court decisions cannot become matters of lottery. The predictability of outcomes of civil and criminal litigation is central to rule of law. In order for people to plan their affairs and make decisions about the future, they need to know first what the law is, and second, how the courts are likely to interpret and apply the law. That is an important reason why people seek legal advice, after all. The less predictable court decisions are, the less confidence the public would have in justice administration, and the less they are likely to rely on law in making decisions that may have future consequences. Predictability of legal outcomes thus gives credibility and legitimacy to the judicial process. The fourth concept, in my view, is what I have referred to as the procedural fairness. We all know that procedure should be the handmaiden of justice. The procedural rules by means of which our civil and criminal justice is delivered are very important. Procedural rules must be effective and responsive to the needs of the users. This entails three qualities. The rules should be just, they should be fair, and they should be effective in resolving civil and criminal disputes. Unfair, outdated, or rigid rules of procedure cannot produce fair results. On the contrary, they can very easily become traps for the unwary. Reforms can be slow, and justice administration systems may not have kept pace with increasing workload and the demands of modern civil and criminal litigation. Sometimes there's a deliberate abuse of useful procedural tools. But in my view, an indispensable concept is the procedural fairness. The fifth concept, in my view, is the speed with which civil and criminal justice is delivered. It is a cliche that justice delayed is justice denied. Like most cliches, it has a gem of truth. The court is a professional public service whose deliverables in terms of speed and quality of judicial decisions must be measurable and capable of being benchmarked against international best practices. Any reasonable and accountable civil and criminal justice system must operate within a reasonably definite, tight, and acceptable time frame. It cannot operate at a speed chosen merely for the convenience of legal practitioners or the litigants. Delay in civil and criminal justice litigation often leads to loss of public confidence and loss of legitimacy in adjudication, and it encourages self-help. Whilst detailed, modern, and progressive procedural rules are required to deliver speedy justice, the success of procedural rules depends inevitably upon the judges, the lawyers, and litigants observing both the letter and the spirit of the rules. In exercising procedural powers, the judges must be aware, as I'm sure many are, that the rules are means to an end and not an end in themselves. Fair and just exercise of powers means that in certain cases, judges may not accede to applications which are calculated to derail the efficient and effective administration of justice. The sixth concept, in my view, is the appropriate use of technology and artificial intelligence. Digitization is both desirable and inevitable and must be embraced in the provision of court services. In many parts of the world, the courts are moving from paper to digital processes. Progressive courts leverage technology at all stages of civil and criminal proceedings, from the commencement, service of process, service of evidence, to hearing. Court registries are digitized so that court processes can be filed, stored, and retrieved electronically with ease. Electronic disclosure of documents and electronic hearing bundles have become common in many courts. Courts are increasingly using technology, digital technology, to manage litigation, the starting and processing proceedings and applications in civil and criminal litigation. And in some countries, bail applications are made digitally. Tax challenges are made online. Employment litigation is conducted online. And even if you go to eBay and Amazon, you find that they have online dispute resolution. It may not be perfect, but it's perfectly effective in delivering solutions in cases where there are disputes. So the essence of digitization is that stakeholders can file online all required processes and evidence and participate in dispute resolution through virtual hearings. The COVID-19 pandemic has, of course, accelerated digitization of dispute resolution, both criminal and civil. Many countries have been able to transition rapidly to partial online resolution of disputes and to virtual hearings, while other countries are embracing and responding to digitization and artificial intelligence. A number of countries, unfortunately, are obsessed with the compatibility of digital technology with their constitutional framework. For example, whether some aspects of artificial intelligence and the use of the digital technology are compatible with provisions regarding open justice or fair hearing. The seventh concept that I would like to draw attention to is the clarity in the definition and allocation of jurisdiction between different courts and tribunals. Legal certainty is a core aspect of the rule of law. How a country defines and allocates jurisdictions between different courts and tribunals is important and is an important aspect of the rule of law. In federal systems, for example, a definition and allocation of jurisdiction between state and federal courts must be crystal clear. Litigants and their legal advisors must know with certainty what the appropriate court or tribunal for commencing their matters is. This is a foundational requirement, being the very first step in any dispute resolution. The eighth concept, in my view, is a reliable and effective appeal system. Appellate courts exist to correct errors in the decisions of inferior courts. They are an integral part of a dispute resolution tree. Unless they are reliable and effective in discharging their corrective or correction function, public confidence will be eroded and the legitimacy of their decisions will be called into question. The ninth concept, in my view, is a robust regime for the award of adverse and wasted costs. The court is a valuable but finite resource, and the court time is at a premium. How it is used by stakeholders is therefore very important. The successful party should recover its costs from the unsuccessful party. In civil litigation, adverse cost orders are the principal deterrent against abuse of litigation. The threat of adverse costs can engender responsible behavior by litigants and their lawyers. In assessing costs, the court will have to evaluate the conduct of the parties during the proceedings. In particular, whether it was reasonable for a party to raise, pursue, or contest particular allegation or issue. In a similar vein, wasted costs are targeted primarily at legal practitioners who have conducted themselves or the proceedings below proper and satisfactory professional standards. Hostile wasted cost orders are exceptional and should be exercised sparingly. But even with such caveats, wasted cost orders are appropriate in certain circumstances and should be made against all erring lawyers, regardless of their seniority or standing in the legal profession. And finally, the 10th, a justice system which is fit for purpose must have an effective judgment enforcement regime. There must be an effective regime for the enforcement of court judgments in those cases, which may be many, where the judgment debtor or losing party has refused to pay. This is particularly important in systems where there is a culture of disobedience to court orders. If these features are present in the administration of justice in any legal system, the judgments of the courts would and should command respect and public confidence. And in turn, the administration of justice could claim legitimacy. There would be public allegiance to the courts, and other legal institutions, and voluntary obedience to law, regardless of reward and or punishment. This requires that the public not simply to accept the constitutional or statutory basis of a court's authority, but more importantly, to accept the court's moral authority. The public would only accept the court's moral authority if it trusts the way that the court exercises judgment, including moral judgment. As one writer put it, the concern is not with the authority of a law, it is with the authority of the legal institutions that administer the law. In my view, if those features are present, most litigants and their legal advisors would be reasonably satisfied with the outcome of the judicial process. So what is the position in Nigeria? How do we localize these features to ensure that we have a system which is fit for purpose? There are many challenges confronting the administration of civil and criminal justice in Nigeria, but all the challenges fall into three broad categories. The first is insufficient institutional capacity, both human and infrastructural. The second is inadequate funding. And the third is a poor attitude of the three key stakeholders in justice administration, namely the judges, the lawyers, and the litigants, and often the lack of cooperation between these three key stakeholders. In some instances, what is happening in our courts is quite frankly catastrophic and tragic. And it's a matter that we should all be very gravely concerned about. We can break these three problems down into so many subtopics, but in essence, our problems boil down to insufficient institutional capacity, inadequate funding, and the poor attitude of the three key players in justice administration. These problems lead to other problems. For example, delay. Of course, we know in Nigeria, and it is often said, the problem in Nigeria is not access to justice, it is exit from justice. Once you engage with the justice system, how to extricate yourself from that system becomes the problem. So also, we know that the allocation and the definition of jurisdiction between the federal and the state courts has generated so much needless litigation. And it is a real blight on the system that almost 47 years after the revenue courts were created in 1973, a lot of disputes still surrounds the question whether the appropriate venue for litigation is the federal high court or the state high court. No system can tolerate such considerable waste of resources as the amount which is devoted in Nigeria to determining whether a case has been issued in the appropriate court. And of course, if you look at the appellate decisions, you find that over 40 of them concern the definition and allocation of jurisdiction between the state and the federal high court. But this is not, it's not rocket science. Australia, the United States, and many other countries operate satisfactorily federal system. And they do not waste anything like we do in determining which court has jurisdiction, but it just shows how we have failed at various points. These three concerns also lead to what many practitioners are used to, jurisdictional objections. In my view, the single most serious deficiency that the courts themselves have foisted on themselves is the misuse of a so-called jurisdictional objection. In Nigeria, once an issue is characterized as procedural or as jurisdictional, any infringement is said to be fundamental. So jurisdiction becomes a weapon which strikes blindly in all directions. It becomes a catchphrase, it becomes a trap for the unwary. Many systems have abandoned the distinction between rules which are said to be mandatory or rules which are said to be directory. Instead, they focus attention on what the intention of a lawmaker is. What's the lawmaker intend? What should the consequences of non-compliance be? What prejudice has been caused to any party? But in Nigeria, we don't bother to inquire about these type of issues. We ask, did they comply? And we say, where statute prescribes a particular way of doing things, no other way will suffice. But there is no magic in any of those formulations. You could have a competent system where statutes has prescribed something, but where there is non-compliance, but the courts have looked at the purpose of the legislation, the mischief that the legislation seeks to cure, and then adopted an interpretation which gives effect to the statutory intention. We should try and do more of that. And I'd like to illustrate that point by contrasting two decisions of UK courts, the UK Supreme Court and the Nigerian Supreme Court. The UK case that I'd like to mention is a case called Soneji, S-O-N-E-J-I, which concerned Section 72A of the UK Criminal Justice Act 1988. In that case, Kamlesh Sonej and Mr. Bulin had pleaded guilty and were convicted in April 2000 for conspiracy to convert property and move it abroad, knowing the property to have been obtained through criminal activity. Under Section 72A of the Criminal Justice Act, the confiscation order was required to be made within 6 months of a conviction. In practice, the confiscation order was not made for more than 18 months. And the lower courts interpreted that non-compliance as depriving the court of jurisdiction to make a confiscation order. Since the rules provided for 6 months and the confiscation orders were not made within 6 months, the lower courts in England held that the non-compliance deprived the court of jurisdiction. Very familiar, something that could happen here. But the UK House of Lords, as it was at that time, now Supreme Court, took a different view. They started by saying that the distinction between rules which were mandatory and those which were merely directory did not really assist. The focus should be on what Parliament intended should be the effect of non-compliance. And looking at the mischief at which confiscation orders were aimed at, the court took the view that Parliament did not intend that the court should not perform its duty of confiscating proceeds of criminal activity merely because for some reason the process was not concluded within 6 months. They held that the proper thing to do was to focus on the consequences of non-compliance, to ask whether any prejudice was suffered by the criminal, the convict. And taking all those factors into account, they held that the non-compliance did not deprive the court of jurisdiction and that the confiscation order made at first instance was properly made. So they upheld the confiscation orders. In contrast, in a Nigerian case called Zakari against the Nigerian Army, Captain Zakari was the chairman of a task force which was charged with responsibility for detecting those who were responsible for using nitel lines illegally. Instead of discharging his functions, he took a bribe of 40,000 naira from some illegal Yahoo boys who were tapping nitel lines illegally. He was court-martialed. The requirements of a court-martialing panel was the requirement was 3 officers who must be at least of the same seniority as himself or senior to him. His court-martial had 4 members. 3 of them were his seniors. one was doubtfully his senior or junior. There was some issue as to whether the fourth one was senior or junior. It was assumed that the fourth one was junior, but the requirement was to have 3 members, and 3 members were senior to him. He was eventually convicted. He challenged his conviction, and the Supreme Court held that the challenge was valid. Notwithstanding that there was quorum, which was 3 members, the fact that there was a superfluous 4th member meant that following the famous Madukolo and Nkemdilim case, following that case, the court held that there was some disqualification as to some members of the tribunal. As a result of that, the question whether this army captain took bribe of 40K was not significant. The question what the public interest required was not significant. The Supreme Court, invoking the catchphrase, you cannot play something for nothing, set aside the conviction and set him free. And you have to ask, in whose public interest is that? How does such a decision serve the public purpose? Why is it that the Supreme Court is so predisposed to taking refuge in catchphrases and formulas instead of analyzing issues which require analysis? A potentially more catastrophic consequence is the recent decision in the Ojikalo case. The Ojikalo case arose from Section 396, subsection 7 of the Administration of Criminal Justice Act, which provides that where a high court judge is promoted to the Court of Appeal, he could continue sitting until the criminal prosecution is concluded. Now, if I may add, this happens in virtually all the common law countries that I'm aware of, England, Hong Kong, Canada, Australia, without any statutory provision. But in Nigeria, just to make assurance doubly sure, we put this in the statutes saying that they could continue. But the Supreme Court in the Ojikalo case acquitted, discharged him, let me not say acquitted, set aside the conviction on the basis that Mr. Justice Idris had already been promoted to the Court of Appeal by the time he concluded the trial. The Supreme Court did not take into account the fact that it was Ojuzo Kalu's lawyer who requested that Justice Idris should continue the hearing so as to conclude it instead of having to start afresh. And you have to ask also, what type of senior lawyers do we have? Where a senior lawyer says the court should do something, and the court does something with the consent of all the senior lawyers involved, and at the end of the day, the senior lawyer challenges it, and then a Supreme Court, which is supposed to be a policy court, upholds the challenge. And what are the technical reasons? Because sometimes the Supreme Court gives the impression that it alone understands logic. It cannot be right. It said, it relied on 2 provisions, Section 253, which said it had to be a judge of a federal high court. And the second one is Section 290, which provides for the administration of the oath of allegiance and judicial oaths. It is difficult to see even the relevance of those provisions, let alone that those provisions can have the determinative and destructive effect which the Supreme Court ascribed to them. And in doing so, the Supreme Court did not pay any heed to the objective of Section 396, subsection 7, which is to correct the endemic delay in criminal litigation arising in part from the promotion of judges. Does the Supreme Court require such a minor procedural step to be corrected by amending the Constitution? So we have to ask ourselves, how do we ensure that our justice system is fit for purpose when we have judges taking that type of self-destructive approach? That's a problem. It's also very similar to what I call the obsession with matters of procedure. Because everyone who has been to a Nigerian court knows that Nigerian law is excessively and self-destructively procedural. Nigerian civil and criminal justice system appears beholden to procedure at the expense of substance. Our civil and criminal justice system is obsessed with matters of form, excessive focus on form. And you see this at different stages of litigation. For example, who should sign an originating process? The small matter of Boma Alabi and co, as opposed to Boma Alabi, that can nullify proceedings in which millions of dollars have been invested over a 10 or 12-year period. And the Supreme Court apparently says that this is inevitable because of Section 2 of the Legal Practitioners Act. So one has to question some of these false logics which appear to underlie the administration of civil and criminal justice in Nigeria. If all your I's are not dotted and all your T's are not crossed, you'll be in serious trouble. And that's why I say that Nigerian law is often a trap for the unwary. When you read the law reports in Nigeria, you don't learn much of substantive law. You'll learn a lot about procedure. And this is a serious deficiency in the system, and we see it happen all the time. For example, in the P&ID case. So you have senior lawyers engaged. Instead of engaging with substantive issues of contract law, the first objection is jurisdiction. I have been in arbitrations abroad where senior advocates of Nigeria, even one of them, a former attorney general of a federation, was arguing that Nigerian law does not recognize arbitration because arbitration is not a public hearing, and therefore Section 36, subsection 3 of the Constitution is infringed. You have to ask yourself what type of system allows itself to be brought into such measure of disrepute by its own principal actors. So the solution is not to have beautifully drawn rules. We have 2019 Lagos State High Court rules, 2019 Federal High Court rules. Will they make any difference? Absolutely no difference. Did Lagos State not introduce fast track? I have a case of fast track, which is now 7 years, and it's fast track. So you wonder if it was slow track, where it would be. But so the issue is not the existence of these salutary rules. It is the attitude and the mindset of the operators, the lawyers, and especially the judges. And you also see that in the very weak case management regime, where because the judges are often not prepared themselves, they haven't read anything, they accede to very spurious applications which delay and hijack cases. And I'd like to say something very briefly about court registries. Anyone who has been to some of our courts will be shocked about those courts. You can find heaps of file almost falling on the parties in court and the litigants. And you ask yourself, how can court registries be so disorderly? I know that many people who have been to Court of Appeal and Supreme Court have experienced even the Supreme Court performing registry functions in open court by asking you, when did you file your paper? We can't find this process. We can't find that. It's not because rules don't exist. It's simply because we as the operators of the rules have shown ourselves incapable of operating the rules. Why should a final court like the Supreme Court be asking you in open court where your processes are when it has a registry? When I'm not the registrar of his registry, he's asking me when I filed my papers, can I lend them a copy and so on. And you look at that and say, look, how low can you fall? We can't just blame people for all our problems. As I said at the beginning, there is no Angel Gabriel who is coming to rescue us. We created the mess. We have to solve the mess. We have to reform our registries, make sure that they use technology, and everyone has seen that in the problems of the COVID-19. Whilst other countries adapted to virtual hearing quickly, in Nigeria, we haven't. I don't know of any court where there's virtual hearing, but I don't even know of many courts where you can file your processes electronically. I know that the Lagos State says that, But in my own experience, it is faster to file a physical copy than to file an electronic copy. And so what's the benefit of electronic filing if it takes 1 week to file electronically, whereas you could file a paper copy within a day or two? Ladies and gentlemen, I thought I should raise those issues for discussion so that we can all see how we can take the administration of civil and criminal justice in Nigeria forward against the principles, against the 10 principles which I benchmarked. Thank you.
Thank you very much, Prof. These are very interesting points that you raised, and would engage you further on some of them in the course of our discussions. Personally, I mean, I would engage you as well, because there's some of those points that will need further clarification. I mean, straight away, we would invite His Excellency, Professor Yemi Osinbajo, Grand Commander of the Order of the Niger, Senior Advocate of Nigeria, to give us his remarks. Those remarks should have come in earlier, but there were issues with upgrading His Excellency to a participant, a discussant. We all know His Excellency. I don't need, it's a very easy task introducing His Excellency, but I just want to mention something, because Professor Osinbajo SAN is someone I'm proud to say that I share some kind of history with. Prof, you would recall on the 17th of December 2014, I think both of us were at the Supreme Court in the case of Abegunde and Ondo State House of Assembly. We're on opposite sides, unusually, because I always love to be on the same side with Prof. But in this instance, we were on opposite sides. It eventually became a locus classicus decision. Now, the point I want to make from this particular day was that was the day that Professor Osinbajo SAN was nominated as the running mate to the incumbent president to contest elections. Now, critical thing is this. At that point, I mean, his nomination actually happened at a point where he was at his work desk. Your Excellency, I'm not sure of any Nigerian politician that shares that history with you, that on the day you're going to be nominated as Vice President of Nigeria, you're not lobbying in some particular location or asking that your nomination should not be cancelled. You were at your work desk, and I recall us walking out of the Supreme Court and you getting a call from a serving minister now to break that news to you. Prof, we appreciate you in the profession. Please, we always like to hear from you, and you have the floor, Your Excellency.
Thank you very much. Thank you very much. Bode, thank you so much for the very kind words and the very kind introduction. As you can imagine, after that occasion, I have not had the pleasure of wearing my wig again, and I have only grayed now so much that I'm not even so sure that I need a wig if I do show up again at the Supreme Court. I'm extremely grateful to the firm of Wole Olanipekun & Co., conveners of this important conversation on our system of administration of justice, for this very kind invitation. Chief Wole Olanipekun is without doubt one of the most consequential lawyers in not only in our country, but perhaps even in the Commonwealth. Today, his exceptional success with novel constitutional constructs is swiftly becoming the stuff of legend. But these days, he is doing his best, and I want him to listen to this very well. These days, he's doing his best to enjoy the very huge fruits of his labor, and has sensibly handed over the tougher parts of running the law firm to his two exceptionally brilliant chiefs of the old block, Dr. Dapo Olanipekun, Senior Advocate of Nigeria, and Mr. Bode Olanipekun, Senior Advocate of Nigeria. I commend you both for this exceptional idea and the execution of this summit. This theme covers a very broad remit, and just after listening to Odita covering the wide range of issues and with such incredibly appropriate examples and illustrations, one really would rather not say anything, but just go straight to the discussions so that we can make our contributions. So what I would try to do is to focus my comments on the responsiveness of our system of administration of justice to the ends of social justice, or the social ends that is to serve. And I'll just mention a thing or two about some of the other infrastructural issues at the end of my presentation. We are, at a moment in history like no other, a global pandemic of a magnitude probably never seen before, and the worst global economic decline in a century. But economies, like politics, is local. Here in Nigeria, we were already grappling with issues of poverty, entrenched inequality, disparities in access to social and economic opportunities, constraints to access to justice. And I think as Fidelis said, not just access to justice, but perhaps more importantly, exiting justice, the justice system, and the diminishing faith in governing institutions generally. At the same time, insecurity in parts of the country, stretching law enforcement infrastructure to its very limits. But we are also at the most technologically advanced moment in human history. And this is the same for us in Nigeria. With artificial intelligence, the Internet of Things, and now even 5G, redefining commerce, medicine, entertainment, and even how we work and play. The conflation of these events is both enormously, in my view, exasperating, but it's also incredibly a hopeful time. And for our system of justice, it offers great opportunities, and we must not in any way diminish those opportunities that it offers. But we are faced today with demands for both structural and philosophical change in our administration of justice system. And I cannot, I can't but help repeating, how well Fidelis put a lot of these issues. But the big question is also the relevance of our paradigms of justice to the major socioeconomic circumstances that confront us. The law is a social construct and makes sense only within a social context. To treat the law as something apart from society or as a body of technical abstractions is to strip it of meaning and to alienate the legal order from the very people that it is meant to serve. Consequently, a definition of justice that focuses on social and economic rights of the people is not only meaningful, it is certainly more just. Of course, these rights, as we know, include the right to shelter, food, employment, education, a reasonable standard of living, a national living wage, a national minimum wage, care for the elderly, pensions, unemployment benefits, and the welfare of the physically challenged. Our progress in the observance of socioeconomic rights must also be prosecuted in terms of the struggle to reduce the basic problems of ill health, malnutrition, illiteracy, farming, etc., which daily afflict our people. Where social and economic rights are unsecured, people are unable to fully maximize their civil and political rights. So for instance, access to qualitative education enhances and enriches freedoms of expression, thought, and conscience. Conversely, pervasive illiteracy can nullify the entire idea of freedom of expression. In the progressive vision, political rights and socioeconomic rights are mutually reinforcing. But socioeconomic rights, even where they are wholly justiciable, mean nothing unless there is a fiscal commitment to enforcement. And so this is crucial, because it's a crucial, in my view, intersection of politics, of ideology, and of our notions of justice. And this may explain why the opposition in Nigeria was prepared to abolish our social investment program if they won, while our party's understanding of the imperative of delivering social justice was the provision of a massive social safety net, or at least the beginnings of the provision of a massive social safety net. This was a fundamental feature of the party's manifesto. So our social investment program, which is possibly one of the most ambitious welfare programs on the continent, and our effort to expand universal health insurance, all aim at ensuring that our most vulnerable citizens are not abandoned to the vicissitudes of fate. Consequently, socioeconomic rights, where they find fiscal support, is absolutely crucial. And then if they do not find, if they don't find fiscal support, obviously, the whole cause is lost. It's of course evident that without social justice, legal justice, in any sense, is unattainable. The degree to which citizens are in possession of their socioeconomic rights also has a direct accessibility thereto, shall be secured and maintained. It's significant that the framers of the Constitution enshrined access to justice along with socioeconomic rights in the directive principles and objectives of state policy. And this indicates clearly that they saw access to justice and the integrity of our justice system and socioeconomic rights as related imperatives. And I think that's the right construct, that's the right framework. There's also a growing recognition, especially in criminal justice, that the model of adjudication that we're accustomed to, which largely dispenses retributive justice, is not entirely adequate to meet the demands of justice in the various complex scenarios and situations that confront a developing country such as ours. Given the tensions and frictions generated by contending passions and grievances and the social reality of inequality and inequity, there's also a recognition that some of the most serious situations, which threaten to even sometimes, break the fabric of society, require much more than just retributive sanctions by a judicial system. They require restorative justice to bring about healing and the reconstitution of communities. This is one of the approaches that we're looking at as part of our efforts to resolve protracted ethnic and religious conflicts. In many, many cases, it's not enough to arrest, detain, and then prosecute and jail a terrorist or jail someone who has abducted children for years. There is a need somehow to find a process by which restorative justice can be brought to bear, by which the communities can feel somehow, by which their feelings of violation can be assuaged. Already the National Policy on Justice embodies some of these prescriptions and offers pathways of innovation for more holistic approaches to justice delivery. There's still much work, of course, to be done in this respect. But just to mention as I close, just a few of the issues which I've described as infrastructural issues. How do we ensure that we attract and appoint only the best amongst us to the bench? How can we do, what can we do about unreasonable delays in justice delivery? How will technology affect our administration of justice system? What needs to be done to maintain the integrity of our judicial processes and outcomes? To take the easiest first, and I'm not going to make any elaborate comments, as I said, I endorse fully practically everything that Fidelis said. There's little doubt that technology has already permanently changed the way we do business. The Supreme Court, in the wake of the pandemic, endorsed virtual court proceedings. So, I mean, clearly, at least the doors have been opened for whatever the implications of virtual court proceedings mean. Digitization of trial processes is now inevitable, and there are very many easy-to-use models. This will by itself, in my view, impact trial times. Recording proceedings will be easier, and so will several other things. And I agree with Fidelis that sometimes the technology might be slower than manual processes, especially because we haven't got the technology right. But I think that with more frequent use and with states like Lagos, we'll probably get it right much faster. We've been at this issue of digitization for quite a few years now. But I think that it's getting much easier to adopt some of the best models that there are. But the important correlation between the cost regime and the speed and efficiency of trials, again, is a very crucial issue. We cannot have the cost regime we have today and expect that lawyers will not engage in dilatory tactics, especially where the lawyer knows he has no case. So really, I fully endorse what Fidelis has said in his presentation about how the cost regime should influence the way that trials run, and also how dilatory tactics are punished by the sorts of costs that have to be paid by counsel that engage in such conduct. We must take the opportunity also to rewrite procedural rules, to remove needless processes and rituals. And I think, again, to the point that Fidelis made, this entire approach of just a completely technistic way, it really has, it has given rise to the most absurd outcomes. The obsessive, and I think that's the word he used, elevation of form over substance. This is obviously a matter that we must take seriously, and it's a matter that we must address, not just as professionals, but we must involve all the arms of government. I had the privilege of speaking at a webinar on appointment of judges, I think about 2 weeks ago. And this matter also came up. I think it's important for us to sit together, that is to say, the leadership of the legal profession, the executive, judiciary, and the legislature, to take a second look at some of these issues, because really, what's the point of the whole I mean, if you look at judgments, just as you said, some of the judgments where there's just been an unnecessary emphasis on technical outcomes, where in fact the entire justice of a case is just made ridiculous. I think, when a case is decided right, when justice is done, there's a certain, practically everybody feels that justice has been done. And it's not a very difficult thing to achieve at all. I mean, and I think that every time that technicality is raised over the justice of the case, it just leaves a sour taste in the mouth, and everybody does feel that something has been violated. So it shouldn't be a very difficult thing at all to get the justices of the Supreme Court and a lot of our justices to understand, what needs to be done and to do what is required. On judicial appointments, it's clear that a merit-based system is absolutely necessary. We need to insist on mandatory tests and interviews for all applicants. And I'm sure that this matter will be addressed in detail by, I know we have someone from the UK on judicial appointments who will be looking at the system in the UK, but clearly we need to look more carefully at how our judges are selected. And there has to be an objective process of selecting justices. And we cannot insist that the only way to become a judge is to be a career person, or at least to move from High Court to the Court of Appeal and Supreme Court. We must be able to bring in practicing lawyers. We must be able to bring in academics, to be justices of the Court of Appeal, to be justices of the Supreme Court. And if it requires rewriting the rules, then let us rewrite the rules so that this can be made possible. Besides, I think that the point which has been made again by Fidelis about the fact that we're not going to get angels to reform our system, is going to be done by ourselves. And I think we in the legal profession, even if only for self-preservation, even if only to preserve our own profession and our means of livelihood, if we have no higher objectives, we owe it to ourselves to change all of what we're seeing. And it means engaging with the Supreme Court. It means engaging with the government, with the executive, and with the legislature fully to change some of these rules. And I think the case is a very clear and evident one, that change is necessary and that the reform of our judicial system is urgent. Every minute of delay simply worsens the bleeding. So just to say thank you again for the very kind invitation and for this opportunity. And I'm looking forward to some of the discussions as we go on. Thank you very much.
Thank you very much, Your Excellency. It's always a pleasure to hear from you. We appreciate that your time is very precious. Just before we get on to the next speaker, there's a rapporteur for this event who is not a lawyer, is an investment banker and also a columnist. He's also written a couple of books. He has aggregated questions from the public, and we just thought it was right that on this subject from a non-core participant in the justice sector should pose a question to Your Excellency, so that in just a few minutes, Your Excellency will respond to that question, to the question from the rapporteur is Joseph Edgar. Joseph Edgar, please, can you, a quick question for His Excellency.
Okay. Good afternoon, Your Excellency, Professor Yemi Osinbajo. I must confess that's a huge privilege, and that I've spent the last 24 hours practicing with my in-law, Fumi Ajayi, on how to pronounce your name. Up until 10 minutes ago, she was saying it's Osinbajo, and not Osinbajo. Well, for me, I've listened very carefully to Professor Odita, and I've also listened very carefully to you. Wonderful presentations, and I must say thank you for that. You know, but the issue on the ground here now is that two issues. There is a huge disconnect between the people and the justice system. There's a huge lack of confidence in the ability of the justice system as presently constituted in providing the much needed succor to the people. So you begin to see people wanting to take laws into their hands. Take the issues of rape. We hear so many cases of people going to social media instead of taking advantage to get all the processes and the procedures that the justice system provides for them to get succor. You hear people say things like, oh, I know I won't get joy if I go to the police. I know even if it gets to the police, gets to the courts, 8, 19, 20 years, like Professor Dare said, is nothing here. You know, and that's dangerous because it would lead to apathy. I would try very hard not to mention some very recent happenings in some parts of the northern part of the country where you begin to see people wanting to take arms in their hand. That's because of the seeming failure of this our justice system. So I hear you speak on different fora. I hear so many freelance people speak on different fora, and I sense a very permit me, sir, to use the word pathetic, sense of helplessness on the part of not only we that are on the ground, but those of you who are supposed to lead and provide us with this comfort. Everybody seems to know the problem. Everybody seems to know the solution. But who is lifting the finger to provide the specificity, the pragmatism that we need to bring about this effective change? So my question to you, sir, this morning is, what can be practically done very urgently? Because some of us are beginning to feel that we may not even see it in this our lifetime. My niece is 15 years old. She's on this program. She wants to listen. She's listening carefully. Where is the specificity? Where is that reformer, that reformist movement that we need to bring the much needed succor. Because without the justice system, it's over. This administration has challenged very severely the justice system in its proclamations, in its ability to obey legal court orders, in its attitude towards principal officers of the judiciary, and all of that. And everybody is saying the same thing you have said this morning, the same thing Professor Dida has said this morning, the same thing every other speaker is going to say this morning. But I do not feel a sense of purpose in seeking long-term solution to this problem. That's my question. Who will lift the first finger down? Thank you.
Thank you very much. Thank you very much, Joseph. And I think, again, I agree fully with you about where we are in terms of the disconnect, to use your own words, between the people and the justice system. And really, to be fair, you will find that because of the systems that we run, the reform of the justice system is a very many-sided thing. It's not one. It can't be done by one segment. It cannot be done by the executive alone. It cannot be done by the judiciary alone, because obviously it needs laws, and it simply cannot be done by the legislature alone. And this is why it makes it even more complex. Because really, every reform, every attempt at justice reform has to have all of these factors in, because of the system that we're on. We run separation of powers. We believe in the separation of powers. Anything that the executive does in response to something the judiciary does is always looked at from the point of view of interference. Are we jeopardizing the independence of the judiciary, etc.? So I think the first problem we have, of course, is the fact that we have to work, the executive, the judiciary, and the legislature, as well as the legal profession. And justice, again, the whole justice framework has that difficulty. I have some experience, and it's relatively small, of what we did in Lagos State, while I was Attorney General. We had, an extensive reform in Lagos State. It took, all of 2-3 years to even get a consensus on what to do. We wanted, for example, to check corruption in the judiciary. We changed so many things. We needed to look at by which people complain about corruption and all of those things, and how to ensure that there is always an answer, and there's always a resolution to judicial corruption and all of that. It took a considerable length of time. Even the whole process of ensuring that the system, that there are no delays, we had to rewrite the civil procedure rules, etc. It took a while. So for anyone to suggest, and I cannot suggest that a process will be quick and that and the urgency of it is not in question. But there is a need for us to appreciate also that it is a many-sided thing, it's complicated, and we have to simply look for ways of working together. The first thing is the will to reform. That is very, very crucial, the will to reform. And I can say that I am seeing that critical mass of individuals in the legal profession and in the executive and also in the judiciary who are willing to reform. And that critical mass is coming together, in my view. We're working quite hard to see how we can all come together to make a real change. And I don't think it will be too long before we begin to see some changes. But in a system as wide, as big as ours, obviously you are going to see many, many lapses. And we must also recognize that that is just in the nature That's just in the nature of things. But I firmly believe that a lot of what we have said today a lot of those things can be implemented. We can ensure, for example, that criminal trials, that the process is short and that we get justice within a reasonable time. When electoral matters were taking 3 years, I mean, if you complained that elections were rigged against you, etc., the person who rigged the elections will be there for 3 years while you're in court. Today, there is a standard. The trial must be concluded within 180 days. There's no reason why we can't insist that criminal trials and other trials must be concluded within a time frame. It is merely a matter of law. So those are, in my view, low-hanging fruits that we can quickly address. Issues like you've said of rape and all of those, are important issues that we have to take into account. We must create systems as well, because don't forget that rape, there are also all sorts of sociological issues and barriers that need to be encountered with rape. Very low reportability, people hardly want to report it. The way the system, which is really a male chauvinist system, responds to rape cases is also a problem. So we need a change of mindset, as well as the legal system responding adequately and promptly to situations where rape has been reported. I don't think that we cannot change this system. I believe we can, but it's not going to be. There's no silver bullet, as it were, and it's not going to be an immediate, like tomorrow thing. But I believe that movement has started, and the sorts of discussions that I'm hearing today, and the kinds of coalitions that are forming, I think that we'll be able to make a difference, and we'll be able to make a change. And also, the last point I'd like to make is that when we did the reforms in Lagos, for example, we found ourselves frustrated by the fact that the appellate system, as you know, states have their own, run their own legal systems. But the appellate system is a federal system. So no matter how fast you're going at the state, you are still stuck when you get into the appellate system, where we have absolutely no control. So I think that, working together, the subnationals and the federal government and their judiciaries, we can really make a fundamental difference and fundamental change. As I said, many of us, I'm sure, and I think you caught it, many of us share the frustration that you've expressed. But I very strongly believe that we can really make a difference, and we can change this situation. Thank you.
Thank you very much, Your Excellency. It's an absolute pride that you're still one of us, and that one of us is Vice President of Nigeria, and that these issues are gaining attentions at very high levels. I can attest to the fact that you led a very strong system of innovative changes in Lagos. To be honest, I was not yet a lawyer when you superintended, so to speak, the new rules of Lagos State, and a simple step as the filing of written addresses, which was the product, as simple as it looks, was the product of very incisive and visionary thinking, is now what all of us enjoy today. So I imagine, as a lawyer today, if I still had to go to court to make oral arguments on every single motion, we would be talking of years and years on end for litigation. And Your Excellency, that single intervention that you did in Lagos State at that time reverberated across the entire country. So it just shows that these simple steps can have long-term effects. Again, we're very grateful for your time, and we'll move straight to the next speaker. Is Boma Alabi still with us? I think we'll take Bree now. Bree, welcome to Nigeria, Bree.
Thank you very much. I very much enjoyed telling people this last week. I'm having my first trip to Nigeria today. I hope to come in person before too long. So thank you very much for inviting me. It's a great honour for me personally. The JAC is also the Judicial Appointments Commission, very appreciative of the opportunity to talk to you, and apologies that our chair, Lord Acker, was not able to be here, so you in those circumstances have to make do with me. So my contribution's obviously going to be a little bit different from everyone else's, in the sense that I'm talking very much from the perspective of what we are doing in the UK. Also, I've done a PowerPoint, so if you'll forgive me while I try and share my screen in order to get that on. I'm not able to share my screen. I've been disabled for that purpose. I don't know if that can be fixed.
Yes. Please try now, Bree. You've been enabled to. Please try now.
Thank you very much. Right, hopefully this will work. Forgive me for a minute, people. Have you got that with the front screen and moving? Can someone let me know if it's working?
Yes, it's working.
Lovely, thank you. Okay, so I'm going to talk mostly about selection, judicial appointment, a bit about judicial training, and I was asked also to talk a little bit about a practitioner's perspective on judicial outcomes. This is all from UK experience, and it's me talking with my various hats. I'm one of the professional commissioners on the Judicial Appointments Commission here in England. We're responsible for England and Wales. I'm also, my day job, barrister, a silk, practicing as an advocate in the English and Welsh courts, and mediator and various other things. So that's where I come at it from. For the most part, as I say, I'm talking for the JAC as a commissioner, but just sort of looking at the UK structure as it now is, selection of judges is undertaken by the JAC, or in the case of the Court of Appeal and the Supreme Court, by a specific selection commission that is put in place at the instigation, in the case of the Court of Appeal, by the Lord Chief Justice, in the case of the Supreme Court by the Prime Minister, but it is made up and operates very much in the way the JAC operates for other judicial appointments, and the JAC participates. So commissioners are on the panels for both of those senior level appointments, and we lend our infrastructure for that purpose. Actual appointment is made by the Queen, which won't surprise you, on the advice of the Lord Chancellor on recommendations from the JAC, or the Lord Chancellor or Prime Minister from the special selection commissions that I've just mentioned. Judicial training, guidance and deployment is dealt with entirely within the judiciary. So at the top of our judiciary, for the courts, we have the Lord Chief Justice. For the tribunals that do a huge amount of work in the justice system in the UK, we have the President and President of Tribunals, and they together are responsible for the Judicial College, which provides all judicial training. And in terms of accountability and discipline, there's an independent office for judicial complaints, which again, in this instance, the Lord Chief Justice and the Lord Chancellor are ultimately responsible for. What's important, and you'll see this particularly when I'm talking about the JAC, is the degree of involvement of non-legal people, lay people, in the various bits of this system, with the exception of training. So talking about the JAC, it's a relatively new creature. It's a creature of statute. It was established as a result of the Constitutional Reform Act. We've been in place since 2006. I've been involved for just under 3 years. It's an independent commission sponsored by the Ministry of Justice, but we are independent of the Ministry of Justice. So government holds the purse strings. We have to negotiate, but then there is a statutory obligation to fund us, so that keeps that in balance. In terms of the work, as I've said, we deal with all judicial appointments except for lay magistrates. And although we don't technically run, we participate in Supreme Court and Court of Appeal. But all other appointments across the court and tribunal system, whether they are for legally qualified judicial members or for lay members, are dealt with by the JAC. And I've just given you the figures for the sort of volume that we dealt with in our last full year. Over 8,000 applications, almost 1,000 appointees. So it's quite a massive task. In terms of who the JAC are, when we talk about the JAC, there are 12 commissioners. We are responsible for every aspect of the JAC, effectively a board, and taking responsible for oversight of all its activities. As such, we're all public appointees. We're all subject to the Nolan principles as public servants. Have to make regular declarations about conflicts of interests in relation to particular competitions, but also generally across the running of the JAC, etc. So we're all held to account and have to be visible in that way. As a matter of statute, our chair must be a layperson, and we currently have Lord Acker, who is a professor of surgery and sits in the House of Lords. He's a non-political crossbencher in the House of Lords. We have 6 judicial members, 3 from the court system, 3 from the tribunal system, and at all different levels. We have 5 lay people, 2 professionals, so myself as a barrister and another commissioner who is a solicitor. And generally, the professional can be solicitor, barrister, or legal executive, and efforts are always made to ensure that it's not 2 from one profession or one part of the profession, and 1 non-legal judicial member, so a non-legally qualified person who sits in a judicial capacity. We have a staff that varies, and a lot of our work is done by our panel members. So the competitions that we run, as opposed to the ones we participate in at senior level, the actual selection exercise in terms of merit, and I'll come on to that in more detail, is done by our panel members. We have an existing panel of lay members, usually about 70. There is a proper open competition selection process for people to come onto that panel. They are people who have experience working in the private and the public sectors. Many have some HR experience or operational experience. They're not lawyers. They're not people who are embedded in the legal system. We get quite a lot of civil servants, but as I say, across the range of charity, commerce, etc., if they have the right sort of skills. We also have a pool of judicial panel members, and the Lord Chief Justice selects those and makes them available to us. So our duties, having been created by statute, are to select candidates for appointment when requested to do so, as I say, usually by the Lord Chancellor, occasionally the Lord Chief Justice. So we are told we need someone to fill this one post, or we need 150 recorders. And then we run a competition to fill that vacancy request. The selection must be solely on merit. They must be people of good character, and we have a statutory duty to encourage diversity across the selection. So we are constantly looking, and there are, as you're probably aware, several areas where our judiciary is not representative of society across England and Wales, and we are constantly looking at that comparison and working to improve that diversity. We also make, although it's not in the statute, our own public commitment to be transparent about application processes, to encourage applications from as wide a pool of applicants as possible, and to make detail about current competitions and their progress visible. And of course, to ensure that all selection processes are fair and everyone receives equal treatment. So all our processes, having had a request, are launched with advertising. There's our own advertising mechanisms, website, we have alert systems, etc., using social media, as well as contact via the professions. And when we're focusing particularly on diversity, we also target advertising at particular places where an underrepresented group may be more likely to see the open competition they can participate in. There's always an application form that will invite candidates to give basic information that's needed, a bit of career information, but also to provide self-assessment, and I'll come back to that in more detail, and to provide details of independent assessors or referees. We call them independent assessors. There will then be eligibility checks depending on the particular role that's being recruited for. That will be checked at an early stage, and then shortlisting of candidates. It's usually after shortlisting that we will start to turn attention to independent assessments. There's a process of statutory consultations. So for each level of judicial appointment, there are particular lead judiciary, senior judiciary that should be consulted. So they are given the names of people who've applied and are able to comment. So they're heads of division, lead judges who will be in a position to feed back into the system anything that's known about particular candidates. We will then move to a selection day, which is where our panels will actually interact directly with the candidates. And our panels are always 2 lay people, 1 judicial panel member, and one of the lay people will be the chair of the panel. After selection day, when we have on the merit assessment, those who are considered suitable for appointment, we will then do character checks, and then with all that information together, it's passed to the Commission itself for selection decisions. So looking at some of those constituent parts, the eligibility and experience very much depends on the role, but there will be a number of years where it's a legal appointment, and that's primarily what I'm focusing on. You'll need to have a defined number of years with a qualification and some post-qualification experience. We also look at the years of service. So as of the date of appointment, how old will an applicant be, and are they able to give the required years of service? Occasionally there is a discretion in the Commission to form a view about that. So if there's any doubt about whether someone is eligible in terms of their qualification, that will come to the Commission to decide. And if someone isn't able to offer the required years of service, the Commission will look at that, and it may be if the business case demands it, i.e. we need, as I said in my interview and thought I wouldn't be selected as a commissioner, judicial bums on seats. But if the need is pressing, there is an ability to exercise discretion and take someone though they can't give the full years that's required. Merit is really the centerpiece of our selection exercise. And as I say, that is an assessment that is done by our panels, our panel members, 2 lay, 1 judicial. Every competition has one of the 12 commissioners allocated to it, and you have responsibility to have oversight on the competition. So we'll sit in on some of the exercises, we'll look at all the papers that are used, the questions, etc., in order to satisfy ourselves and report back to the board that the competition was run properly. We have competency frameworks for every single competition. They vary between the competitions, and I'll come on to those a bit more in a moment, but they're used throughout, and that is what's used by our panel members to assess the candidate's ability to carry out the role they're being recruited for. So what a candidate has to do is provide within the process evidence and demonstrate that they can meet the competencies that form part of the framework. That they either are able to do that now, or that they have the ability in a short period of time to acquire those competencies. And so the competencies or the criteria are really the building blocks of our selection process. And I've put those up on the screen for you. In any particular competition, depending on the role, we will have certainly the 5 that are in the lighter colour: exercising judgment, assimilating and clarifying information, possessing and building knowledge, managing work efficiently, and working and communicating with others. Those are always a feature of all our legally qualified appointments and criteria for them. Depending on the role, if it's a leadership role, then leadership may also be one of the criteria. And for every competition, and you can see this if you look at the JAC website, when we open a competition, advertise, potential applicants can click through, they can see the competency or the skills and abilities framework, and these headings will be there with bullet points underneath that are really geared towards the particular level and standard and the types of ability and behaviours that are being looked at for that particular role. So they are finessed depending on the nature of the role. Tribunals, courts are slightly different, which one they're working in terms of subject matter, but also the level and seniority. And that's really what we are asking for evidence to support in terms of the selection exercise and the merit assessment on that. And as I say, for senior roles that have a leadership element, there is that additional feature. Our senior judiciary got a bit overfaced by having 6 competencies, so we sometimes reformat it as leadership, legal and judicial skills, and personal qualities. But the truth is it has all of these embedded in it. So exercising judgment, assimilating, clarifying information, possession and building knowledge will become legal and judicial, managing work efficiently, and working and communicating others. The things that would have been under that will go under personal qualities. So then the tools we use to evaluate people against those criteria are, you recall I mentioned in the application form, candidates are invited to put a self-assessment. So each one of the competencies or skills or abilities, candidates are invited to look at the framework, look at all the bullet points, and then to write a self-assessment, limited number of words, that really gives examples of when they have demonstrated those skills and abilities. The independent assessors similarly are asked to complete a form which splits out the criteria, and they again are asked to give us examples of when the candidate has demonstrated. And by examples, we're asking people to tell us just enough to understand it of the situation, a lot about what they did, and very shortly the outcome. So it's really talking about asking candidates to talk about when they have demonstrated those skills usually in their practice, but sometimes it can draw on other things. When we have very large competitions, We will use qualifying tests, which are online. So we may have competitions where we have 1,000+ applicants and need to take that down to more manageable levels. So there may be multiple choice questions or very short scenario questions for them to complete online. The shortlisting then draws on the self-assessment, the independent assessment, and the result of the qualifying tests where we've used them. And there, sometimes we just use judicial panel members to shortlist. Sometimes we use, if it's a small competition and we're only going to have one panel, one judge and 2 lay people, they will do the shortlisting together. Sometimes, as I say, when the bigger competitions, we'll have a whole group of judicial panel members who will do the shortlisting. And what we ask our panels or judicial panel members to do is to go through each of the criteria to assess whether there is positive evidence, no evidence, or negative evidence, and then for each of the criteria to categorize the candidate as being insufficient, sufficient, good, or excellent, or something along those lines. And then we are able to see who we are taking forward. In terms of a selection day, each candidate will appear in front of a panel, 2 lay, 1 judiciary. They will have either scenario questions or a role play. Usually they will be provided with the material on the day, given some time with the material, and then they will come in front of the panel and either be questioned about a scenario they've had a chance to look at, or although we haven't been doing this since COVID, we have actors and there is a role play of a court, tribunal, or informal hearing type of situation. And then the second part of a selection day is a competency-based interview. So for the purposes of the scenario questions or the role plays, built into those are challenges for a candidate which are designed to expose their ability, their skills by reference to the competency framework so that the panel can score them against those. And similarly, the competency-based interview will have, working through the panel members, they'll be very clear with the candidate. I'm now asking you questions about exercising judgment. Can you give me an example when? Or that type of thing. So it's very much focused towards those requirements. So our panels provide us with individualized feedback on each candidate. Again, we ask, I should go back, we ask our panel members each to form their own view of how they score each candidate against the criteria for each element. Then they discuss it between them and form a collective view. And ultimately, they will provide us with an overall score against each of the criteria, and that will produce, automated through the system, an overall score for the candidate. But we will have visibility on how they scored on individual criteria at the stage of either scenario and role play and interview as well. And where we have multiple panels, we have occasions where we bring the chairs or the whole panels together for them to talk about what's insufficient, what is sufficient, what's good or strong, so that they are trying to calibrate across them to look for the same thing. And at the end of the process, we take them through a moderation where the commissioner will get involved as well to really challenge and check that they are, as far as is humanly possible, applying the same standard. So as a commission, we've made the eligibility decisions. We're provided with the merit assessment by our panels. That all comes to us, and we as the commission make the decisions about character. Candidates are asked to make declarations about any character issues. We can do character checks with the relevant regulators and other professional checking bodies. There is very detailed guidance sent to candidates. They should declare any sort of offences, however old, any allegations of professional misconduct and the like, or claims against them, etc., whether they're completed or not, and whatever the outcome is, and any issues related to financial conduct. There are many things that, because of the age, because they are not so serious, will not block someone proceeding to appointment, but we require complete candour, and an absence of candour itself will be taken into account in the consideration as to whether someone is of good character and can go forward. So it's a commission decision. It is dealt with separately from the question of merit and separately from the question of eligibility, and it is usually dealt with after merit. If there is something that is very obvious at an early stage, it may be the Secretariat will bring something to the Commission to deal with it at an early stage, but generally it's dealt with after the merit process has been gone through. I suppose what I would say is I'm telling you how it works in the UK and how the Commission works after being in place for nearly 14 years. As the professor said at the beginning, no system is perfect, but good systems don't fall off the trees. And one of the really important things, and things I think is very valuable at the JAC, is that everything is treated as a constant work in progress, that every single competition, a learning points list is collated from those who are participating in it, and that's taken forward and discussed both within the senior staff in the Secretariat and at Commission level in order to review what can we change, what can we make better, which is the constant question. Because very much there is a drive to, whilst perfection is not possible, always drive towards excellent. And so we are very happy to share our experience, to share our approaches, and to hear others. And before I carry on, I should just say I'm finding it very interesting listening in to all the other speakers today, because we think the wider you cast the net and the more you challenge yourself, then the more you expand your thinking and the closer you get to the unattainable perfect system. What we do, as it were, on the ground in terms of building confidence, but also improvement very much in line with that ethos, is not just internal. So we constantly engage with the Lord Chancellor, the Lord Chief, the presidents of tribunals. We engage across the judiciary. We engage with both the professions themselves, the formal organisation of the professions, but also the informal, various specialist associations and the like. We engage with the professional regulators and various lay interest people's groups. So we have direct engagement with various of those people and bodies. We have a number of forums that run, some on an ongoing basis, some to deal with particular challenges or issues. We have a number of working groups. So just by way of example, we have a judicial diversity working group who see the vast majority of the materials that are going to candidates, the role plays, the scenarios, etc., in order to comment on them and tell us if they, from looking at it from their angle, perceive an issue. We also make use of experts at various stages, a lot of statistics, and I've talked about commissioner oversight. Sort of losing track of time here, so I think I'm probably used most of my time, and I'll speed up a bit. Someone can tell me to shut up if they need to. In terms of training, my experience of this is just directly as a part-time tribunal member. I've had some training and talking to colleagues. For most roles that are entry-level roles, there's a 5-day training course, a system of shadowing full-timers working at the level of the appointment, and then mentor judges given to people going forward to help them develop. All judges undergo regular CPD training. That's all organised through the Judicial College, which, as I said to you, is an entirely judicial feature run by the Lord Chief and the President of Tribunals. The trainers mostly are judges, with specialist practitioners being brought in to deal with particular elements or experts in other fields. And the focus is equally across judge craft and substantive content. The time spent is as much on judge craft. And by judge craft, those really are the sort of features that we're talking about: quality of treatment, procedural and engagement, effective communication, independence, impartiality, integrity, and propriety. And I think one of the very strong messages that comes across, and I see as a practitioner, but also in a judicial capacity, and indeed comes up in selection processes through the JAC, that actually it's not just about substantively being impartial, independent, etc. It's about conducting your judicial craft in a way where that is perceived to be. It's not good enough that you are impartial. It has to be apparent and perceived by those engaging with you and watching that you are. So I think that that's quite an important feature. So very briefly, I'll talk from a practitioner's perspective. I think in the UK, our judges probably start, and this is not me, JAC, so our judges probably start with the huge advantage that there is a very strong perception and expectation that our judges are inscrutable, that they are of a very good standard, and so that is what people expect to see. Having said that, participants in litigation do have some very different and curious ideas, a lot formed by society's misconceptions about the justice system, a lot formed by the amount of media focus on the American system, which is rather different to ours in various ways. So the expectations, whilst of inscrutable and good, do have some funny elements to them. And I think for a lot of parties, a lawyer's input in terms of discussing with clients about what's actually going to happen and how the system actually works and what in reality a judge can and cannot do is very important. My own experience is that by and large, if we think about it in terms of the experience of going through the process and then the result, that most clients and indeed other parties, when I do get to speak to them, even if the result didn't go their way, tend to feel like they've at least had a fair hearing. And I think the constituent parts of that, thinking about the things people say to me, are about feeling respected. You know, their name was known, actually used, as opposed to them being dehumanized and talked about by their role, defendant or claimant. The details were correct. There was a balanced focus on things that were being said by both sides. It's important that they understand that plain English in our courts is used rather than jargon, and Latin, you hear it less. It really jumps out when Latin is used by a judge, and they usually say it and then correct themselves and apologize, which has the same effect. People feeling heard and understood, and that's about balancing the airtime, but also reflecting back some of the detail and the story and sometimes the words that are being used by parties or their advocates. And that tends to have a huge impact on people's sense of having had a fair hearing and been heard. And the results, it's always the reasons that matter. when parties can actually understand a judgment and follow it. They may not understand some of the legal argument, but when it's enough of it that they can follow what's being said and can see that whilst they may disagree, there is rational, detailed, clear reasons. I think that helps hugely. In terms of, as a profession, we obviously have our experience of our judges and we know their reputation. I'm sure just the same as all of you who are in practice, you ping around an email saying, has anyone been in front of, any thoughts? And you get the feedback. I think it was quite interesting listening to someone's comment about His Excellency, that he's still one of us. I think that's very much a powerful feature in the British system. We have a divided profession. Most of our judiciary are still at the moment barristers, increasingly solicitors as well. There is a sense that they come from us. Our own sense of ethics and standards are very strong, particularly at the bar where we're self-employed, and it's absolutely down to you. You can't sort of hide behind anyone else or a collective in any way. And so there is that sort of internal culture, I suppose, an informal holding to account, both at the profession and among the judiciary. If someone missteps in some way, then that is known and everyone is conscious of that. If they are seen as sharp, then that is seen as not a good thing. You know, there are bits of UK society where being sharp would be seen as a highly valuable thing, certain areas of commerce, certain sectors, etc. But certainly in the profession and looking at the judiciary, we don't even get to a question of corruption. Sharp is a thing to worry about. So I think that's quite a powerful feature in terms of the culture and culture setting and the role that the profession has to play in that for the judiciary. And now I'm going to shut up and be worried that I went on for far too long.
Thanks, Bree.
I have to take it off the sharing.
All right, thanks. Okay, great. That was a good one. We'll come back to you with a couple of issues in the question and answer session. Mr. Yemi Candid Johnson, SAN, will take on a very critical issue of improper considerations that affect judicial outcomes. It's one of those topics that has generated, or one of those topics that have generated a lot of interest in very recent times. And I'll just have Mr. Candid Johnson come on now to share his views.
Thank you very much. Good morning, and thank you for inviting me. It's a very important dialogue, and I'm, as always, delighted to participate. The topic I've been given is to discuss improper judicial influences, or rather improper influences on the judicial outcome, as well as the expectation, I think, of practitioners in the appointment of judges. And I ruminated over that expression, improper influences. It's very elegant. I think it's a bit like calling COVID-19 a mild flu. But I'm going to take a few minutes, as I've been given. I think I have 12 minutes to take it on. And I should say from the start that to speak on a topic like this for me is almost sacrilegious. I think that judges are priests. As you know, I grew up with judges. I come from a deep and deeply proud judicial background. And I do venerate judges. It is part of our national heritage to install judges on a high pedestal and to venerate them. We dress them in intimidating robes, we seat them on a high bench, and we call them lordship. When I was young, people bowed and fell silent even at the approach of a Nigerian judge outside the courts. And this is for good reason. The work of a competent, independent, and impartial judiciary is elemental to the progress and safety of a free democratic society. But talk of judicial corruption in Nigeria is so commonplace. instances so rampant that they shamefully mirror an open cancer that is killing every Nigerian institution and nullifying their promise to national development. And because I personally know so many upright and diligent Nigerian judges who continue to present their honest best under the most difficult circumstances, it pains me greatly to speak on this subject. The fact is that, save for exceptional examples who hardly receive credit even from their own hierarchy, we're not getting from the judiciary of Nigeria what they promise, and the people of Nigeria no longer believe the legend that the judiciary is the last hope of the common man. In Nigeria today, justice is very often for sale to the highest bidder, and this by a conspiracy between judges, law enforcement, and some of the most celebrated lawyers in Nigeria. Now, we talk about improper judicial decisions and improper influences, and what are these? They entail the breaking of the rules or manipulation of a system of procedure for the determination of issues brought before the court for considerations that are external to the adjudication, maybe for personal gain in the form of money, favor from the beneficiary, among others. It is all corruption, because a judge who has taken any kind of bribe cannot be independent, impartial, or fair. And there are multiple devices by which corrupt motive can be infiltrated into the judicial process. One very obvious one, which resonates with the expression that Professor Dittam referred to earlier on. He spoke about the excessive obsession with technicality. I find that the obsession with technicality not only is often calculated to subvert the purpose of law, and that many judges take delight in doing a hide and seek game behind technical points, ignoring the merits, often to cover a perversion of the course of justice. The second point that I think is quite common is the abuse of ex parte communications. There is an unnatural and quite an appropriate familiarity between some lawyers and judges. Judges are receiving inaccurate or incomplete information that may prejudice their thinking from their friends. There's the acceptance of gifts. The acceptance of gifts is a dangerous social and cultural phenomenon in Nigeria. As we know, a judge cannot be impartial if he accepts gifts or favors or loans by the person whose interests have come or are likely to come before him. Another aspect by which corruption is introduced is the failure to dispose of cases expeditiously. Delay is often regarded as a symptom of inefficiency in our judicial process, but I have seen in many cases that delay has been used as a device to obscure determination, often for corrupt reasons. Actually, my own impression, when I see a judge adjourn rulings multiple times, or I see a judge refusing to sit when a critical decision has to be made, every attempt to slow down the right of a litigant to have a case determined expeditiously and efficiently, I interpret as an intrusion of corruption, and that the judge is operating out of the need to protect an improper influence. And I think many people will have other such examples. Another example in my mind is the abuse of ex parte power of injunctions. This is a huge discretionary power, and judges, it is quite clear in many of the courts, the Federal High Court is a big example, continue to be complicit in the abuse of this exceptional power to grant interim or interlocutory injunctions. This is often abused to gain unwarranted advantage in litigation. It is granted when none of the established grounds for a grant exist, and judges will often make such an order ex parte and allow such an order to be maintained for an inordinate time, damaging businesses of defendants and making the resort to the court system largely irrelevant. Now, lawyers are agents of the administration of justice, and they constitute the judiciary together with judges, litigants, and court personnel. In considerations of corruption in the judicial system, special attention is typically placed on the judges, because the interpretation of the law relies on them. But they're not alone, obviously. The International Bar Association Judicial Integrity Initiative published the Judicial Systems Corruption Note in May 2016, which highlights how corruption in the judicial system is found in the malpractice of other actors within the system, showing the extent that lawyers can enable, contribute to, or even cause corruption in the judiciary. Amongst the most relevant findings are the following. 1, bribery and undue political influence were reported as the 2 most frequent forms of corrupt behavior observed in the judicial systems. 2, the research shows that in countries where political corruption is widespread, the judicial system is likewise perceived to be very corrupt. Sounds familiar. Those judicial professionals who are reportedly most involved in corrupt practices tend to be part of the system itself, that is, judges, lawyers, and court personnel. The survey results in that report suggest that those judges who purportedly engage in corrupt conduct do so most frequently in their interactions with lawyers and other judges. This suggests that such behavior is predominantly focused on internal interactions within the judicial system as opposed to interactions with third parties. Lastly, court personnel are more frequently reported to have been approached by external actors rather than actively seeking bribes themselves. The lawyer's role in perpetuating and perpetrating corruption in Nigeria was the subject of a much publicized speech by the former corruption czar Nuhu Ribadu on the 1st of December 2016. He set out publicly how some of Nigeria's most prestigious lawyers, known as senior advocates of Nigeria for those who don't know, collaborated with Nigeria's most corrupt actors to frustrate the country's effort to eradicate corruption at the highest levels of government. And he named names. Since then, we have had at least one senior advocate of Nigeria convicted for corruption and perversion of justice, another one facing trial. Even the current president of the Nigerian Bar Association is facing trial for money laundering and acts of corruption. And the Attorney General of the Federation sitting in office today is the subject of much publicized allegations of corruption and abuse of office. I'm sure that almost any lawyer in this meeting will be able to identify individuals who pretend to be leading members of the bar. Professor Dita said, how can these be senior members of the bar? It's a hugely important question, because if the leading members of the bar are implicated in the darkest and most subversive aspects of judicial manipulation, then we need to bring an axe and a hammer to the columns of our legal profession. Now, we're going to have to name and shame, or we're going to have to bring disciplinary and even criminal accountability for these frauds. But back to judges, I think that we should wonder, and I was delighted to see Bree's presentation to see a model for judicial appointments, very detailed, very merit-based, and I'll make some comment about that in a minute. But for judges, one should really wonder, what type of person, what type of judge will sit in a magnificent robe, will sit on the pedestal where he's called justice and honorable and lordship, and then will scurry like a rat into hidden corners to share in blood-stained money. And there are judges like this. We need to understand that installing a proper judicial outcome will begin from the appointment of judges or justices to the various courts across the country, that it is critical that only the most qualified candidates are appointed to the highest courts. This can only be ensured through a transparent selection process that is based on the merits of the candidates rather than their association or sympathy or familiar connection with the government in office or powerful special interests or individuals. Although a transparent merits-based system is blithely promised in the 2019 National Judicial Policy, the judicial appointments guidelines in Nigeria, as a case which we've recently filed will demonstrate, are deliberately manipulated and more often cynically disregarded. One must wonder whether any judicial appointment in Nigeria can be credible when the judges themselves in council do not respect their own law and their guidelines. There are minimum principles that should govern selection processes. They're well known and they should be summarized so that people can recognize them. The entities responsible for shortlisting candidates must be autonomous. The appointment of justices must be guided by clear and previously established criteria. Guidelines for a transparent and merit-based system for the appointment of High Court judges must be instituted through the appointment process, and the responsibilities of all actors engaged in the process must be clearly established. Selection bodies must offer opportunities for different sectors of society to provide input on the candidates, which should be investigated. Public hearings must be held with the candidates to assess their qualifications. It cannot be a cloistered and secret process. We have seen the result of that. Efforts should be made to ensure diversity in the composition of the courts. And the entity, in this case, the Judicial Council, involved in selection or pre-selection, should motivate its final decision. That is, to conclude a transparent and merit-based selection, the body should disclose the basis of their consideration of every nominee and to indicate the criteria upon which specific nominees have been chosen. Now, we have a case now, of course, where the Judicial Council is defending a challenge to the last judicial appointments where the council itself has failed to comply with its own regulation, with its own rules. And one would have thought that when this was pointed out to a council headed by the Chief Justice of Nigeria, that it would have been appropriate to retrace their steps. But it seems that it is necessary to challenge the Judicial Council in public proceedings in order to hold them accountable for powers whose parameters they have disclosed in advance but have not complied with. So can we have candidates who have outstanding knowledge of the law, who have excellent oral and written communication skills and analytical competency? Can we have candidates whose commitment to the judiciary as a public institution can be proven? Can we have judicial candidates who have demonstrated commitment to the protection of human rights, democratic values, and transparency, which are the fundamental of our system of government, apparently? Can we have candidates who have an ability to understand the social and legal consequences of their decisions, who have the ability to strike a sound balance between a high level of judicial productivity, the quality of judicial decisions, and a careful consideration of cases? We know what we need. The question is whether we're ready to put this in place. The Vice President, His Excellency, Senior Advocate of Nigeria, has spoken about the will. The will must come from you, sir. Now, as to the current bench, we cannot assume that we will have a upright and standard, fit-for-purpose judicial branch by not reviewing the quality and the output of the judges who currently sit on our courts. And what I would like to commend in the closing part of this submission is that the lifestyle, the finances, and the personal behavior of every sitting judge in Nigeria should be subject to an audit. This is not a remarkable thing. This was proposed in Kenya in 2018 by the Chief Justice, William Mutunga, who is credited with bringing about a revolution in the public accountability and the confidence of Kenyans in their judiciary. What he said was that lifestyle audits in Kenya can tell us who in the public service has eaten what, who continues to eat, and who is likely to eat and what they like eating. Putting it simply so the man on the street can understand. But lifestyle audits are also about conspicuous consumption reflected in expenditure of expensive capitalist toys, travel, residential housing, the possession of skyscrapers. Every day we have judges with billions in their accounts, charity and philanthropy, investing abroad, food, booze, day-to-day expenses incurred in carrying out particular lifestyle. A lifestyle audit, which is a principal tool of corruption verification and determination, is to find out where the money to sustain such lifestyle comes from. If it is found that it comes from raiding and stealing public funds, bribery, corruption, then a public officer, and ipso facto, bit of Latin there, judicial officer, is criminally liable. The methodology of doing this is not rocket science. It should be fairly simple. In Nigeria, of course, even more simple, because every law enforcement agent has the BVN accounts of every judge. Every tax authority knows how much a judge earns and how much he's meant to put into his account. It just seems to me that with the slightest of will, if you wanted to discover the top 10 corrupt judges in the Federal High Court of Nigeria, you could do it within 24 hours. Now, the government of Kenya set up a vetting board in 2011 to implement a constitutional requirement that judges must be proven to be fit for the purpose for which they have been appointed. And this required an audit of all the sitting judges. The Kenyan approach to this was to deny judges the full guarantees of judicial office until they could prove that they were fit for purpose. The Constitution of 2010 in Kenya requires that all judges and magistrates who were appointed under the previous dispensation had to undergo individual vetting. The purpose of vetting, as set out in their constitution, is to determine whether they are suitable to continue to serve in accordance with the rule of law, human rights, and other values enshrined in the Kenyan constitution. The vetting process is being carried out by an independent judges and magistrates vetting board, consisting of 3 Kenyan lawyers, 3 members of Kenyan civil society, and 3 Commonwealth citizens who hold or have held high judicial office. It is not an internal inquiry by judges about judges. The board commenced operations in 2012, and by the end of the year, it interviewed and assessed most of the 50-odd judges, members of the High Court or above, who were liable for vetting. It completed the vetting of the much larger cohort of over 300 magistrates by the end of 2015. The Kenyan board, and it's a model for us, made it clear that it would not be conducting a purge of the judiciary based on crude attributions of collective guilt. Instead, the vetting process would be founded on the rule of law, insofar as it would be an assessment of an individual's responsibility in the light of an overall evaluation of the extent to which the conduct at issue is compatible with the criteria established by the Constitution and the law. So, the board's objective was not to punish, discipline, exonerate, or reward the judge, but to help restore public confidence in the judiciary. Now, since public confidence in the Kenyan judiciary became a touchstone, the main issue with regard to Court of Appeal judges, according to reports and studies, whose suitability was being considered, was not merely whether certain high-profile decisions they had given were legally correct, but rather whether the decision had been so extraordinary in itself, as some that Professor Ditter mentioned, and so embedded in the larger pattern of legally strained decisions as to point to the existence of a judicial mindset that was so manifestly lacking in fairness and impartiality as to undermine public confidence in the judiciary. Respect for judicial independence meant that there had to be room for differences of judicial philosophy and approach. Individual judicial conscience. Judges could be literalist or purposivist. They could be hard or soft on crime, or even become known for being executive-minded. Although the board did not say so, it could have said, in addition, that there was room for honest judicial error. Questions of unsuitability would arise only if the board found that a judge had gone further than this. For example, if the judge had compromised the independence of the judiciary by showing a judicially unacceptable proclivity to immunize the powerful and the wealthy from independent judicial scrutiny. Or to put it somewhat more directly, if there had been an undue degree of bending of the law in order to achieve a predetermined result favoring powerful personalities. Reminds me of the O.G. Kalu case. By the end of 2012, the board had completed its interviews of all those judges who at the time the Constitution commenced had been serving in the higher judiciary. Subject to outstanding review applications, the final picture of this cohort was that 13 of these 53 judges were found to be unsuitable. In a September 2013 interim report, the board classified the grounds of removal as follows. 3 related to failures of impartiality. There were 3 of the 4 Court of Appeal cases which have been discussed in the reports. 5 were for lack of integrity, 3 for shortcomings of temperament and work style, and 1 judge who was found wanting in terms of competence and diligence. Now, I like to quote what I refer to as local examples, because very often when people in Nigeria hear from what is happening in England and what is happening in New Zealand and in Australia and in the United States, they're going to give themselves the excuse of saying, well, this is what these long-established judiciaries and traditions have established. So very often when I'm speaking about problems with our Nigeria, I speak about Ghana and Uganda and Sierra Leone and Liberia and Kenya to show our direct neighbors who have recognized the significance of rectifying the reputation and credibility of the judicial process because they recognize that it is fundamental to progress in their societies. Now, what I've tried to do in this presentation, I hope I'm still in time if I have 1 more minute, is to show that there is a roadmap to understanding, to constructing, deconstructing, and correcting fundamental errors, which at present amount to the sad result that by and large, the judicial process in Nigeria is unfit for purpose. This is a responsibility of both the judges and of the lawyers. And I think this is a family discussion. and that if we can't tell the truth, in my experience, you cannot really find a solution to problems that ail you. So I hope that I have contributed in some small way to providing a diagnosis to some of the wicked problems that assail our own judicial process. Thank you very much.
Thank you very much, Mr. Candid Johnson, for your candid views that are characteristic of yourself. You've always been like this, very frank, and I tell people that you're one of those people that a lot of people should see as role models, and one of those people that still remain as proof that you can lead a very comfortable lifestyle with integrity. So you don't need to cut corners, to be honest, to live well. And I know you live well, and I say, okay.
No comment. Thank you very much. I'll switch off your mic now. Yeah.
Okay, so we'll bring on Professor Pat Utomi, very respected voice in Nigeria, to take us through these issues of institution building. He's been a litigant in Nigerian courts, and he would speak to us about, user experience and a couple of other things. Professor Pat Utomi is still with us, and they will come on almost immediately.
Well, thank you so very much. Let me say how appreciative I am of the privilege of not only being part of this conversation, but being a panelist. I want to say that I am so thrilled and so excited about this quality of introspection that I have witnessed on this platform today. I think that if most thought leaders who are Nigerian were to be participants in this, they would be significantly elevated in terms of their hope for our country. The kind of quality presentations that I've listened to, beginning from Professor Odita through to the last one from Mr. Candid Johnson, just make me feel that, the promise of Nigeria that I like to say from time to time has been sacrificed. It can be reclaimed. I think the starting point for my interjection before I get to my experience is to say how important our lawyers and the law is for human progress, which is why frequently when I get invited to speak to the Nigerian Bar Association, I challenge lawyers to say that it seems to me that they underplay how important a role has been carved out for them in whether society makes progress or not. Frequently when I talk about human progress, I talk about two critical tracks. Of course, there are more variables that are responsible for how man makes progress. But typically I focus on institutions and culture. In a book I wrote many years ago about why nations are poor, I actually have a framework that includes policy choices, leadership, entrepreneurship, in addition to institutions and culture. But let's just say how critical institutions are and how important a role lawyers play is for the building of institutions. Central to the value of institutions is that they actually set out boundaries. And the boundaries that they set out for behavior, which then results in whether sanctions come or whether people feel more comfortable to engage, is critical to how enterprise evolves and therefore how material progress is made by man. The other is culture, and they both play in our conversation here this morning or afternoon. It is critical that the kinds of values that have been raised in the last presentation by Mr. Candid Johnson are taken on board. Lawyers or judges centrally about character. If the system perceives that the characters are flawed, it shakes the possibility of their role in ensuring progress. But more importantly, as institutions, if people do not see that they can ensure those boundaries where acceptable conduct can then ferry through, what you find is that people don't make the kinds of commitments that lead to economic growth and the transformation of society as it should be. I just take a simple example here regarding why we are poor. The argument I like to make as a country is poor. Sometime last year, Forbes magazine published an article that suggested that Nigeria was a money-losing machine, literally saying that if you wanted to lose money, go to Nigeria. Now, what is the major reason why Nigeria is characterized this way, as seen as a money-losing machine? As a professor of business, consultant for many years, when I talk to foreigners who want to invest in Nigeria, one of the first things they say is, well, look at the opportunities, but you know, if a dispute were to arise between me and somebody, the report I have says that I will never get justice, because the person who's wrong will be the first to go to court, and he can keep me there for forever. And justice delayed clearly becomes justice denied. And so I'd rather go somewhere else where I will have a thinner margin, but I can be sure that I can have problems resolved. Now, this perception of Nigeria has gone on for so long that I have always wondered why lawyers don't get very activist around this problem. Indeed, and going back to some of the remarks made by Mr. Odita, Professor Odita in his presentation, if you look at the enterprise arena and look at how people make choices because of certainty or uncertainty about outcomes from judicial processes, you will see why, for example, judges being familiar with the intent of law rather than these what ordinary people consider games with procedure, rules, and therefore, you know, more or less subverting justice, has significantly affected how people believe they can get economic justice in Nigeria, and therefore why there's a low level of actual investment with all the opportunities available. I keep citing when I speak to lawyers, the examples that come out of the writings of Raghuram Rajan and Luigi Zingales in the book Saving Capitalism from the Capitalists. We know that, you know, creative destruction is really what makes for growth in economies. Now, this creative destruction is a function of people who dominate today being supplanted by new ideas. Now, these dominant people of today who are powerful, if the system is so in their favor, as typically the law tends to be, we would get to a position where we will not get entrepreneurship, where we will not get new ideas leading to progress. So we are challenged, I think, in Nigeria to be able to get judges to understand the consequence, the significance of their essentially being able to understand the purpose, the intention. Indeed, it is the argument of Rajan and Zingales in that book, Saving Capitalism from Capitalists, that the United States is one of the economies that renews itself the most, the easiest, because of activism on the part of judges like Charles Brandeis that created the kinds of institutional parameters that allows for ease of attracting investments into startups and so on and so forth. And so that is so important, the role of judges in ensuring property rights, in ensuring essentially that people can get justice when there is a dispute and a process. But what we seem to see, I mean, let's take the easiest one, the Land Use Act. There are many people who have vowed not to invest because state governors, a new governor arrives, does not like the fact that somebody is executing some enterprise. The person has had a C of O for 20 years, invested billions, and the governor wakes up and revokes the C of O and knows that the nature of the judicial processes are such that the fellow can be tied up until he stops being governor and all of that.
Prof, it looks like we have challenges from your end. We can't seem to get Prof. Okay. I'm sure he'll join us back in a few minutes, or well, in possibly less than a minute, hopefully. Okay, before Professor Patutomi joins us, am I on, guys? Yeah, before Professor Patutomi joins us, Professor Odita, there's a question, Professor Odita, there's a question for you from my noble lord, Honorable Justice Ogunwumiju, presently Justice of the Court of Appeal and Supreme Court Justice Designate. For you, Professor Odita, and my lord has said this. I agree with Professor Odita that the principal actors in the dispensation of justice are sometimes engaged in delivery of judgments rather than delivery of justice. I would ask Professor Odita to suggest a jurisprudential philosophy for all the cadres of Nigeria's judiciary. This will be taught to all persons who dispense justice as soon as they take the judicial oath. Will it be the golden rule, the purposive rule, substantial justice, letters of the law rule, etc.? The terminology and what they may entail are legion. I'm hearing from Professor Oshibajo SAN that there's a national policy on justice for Nigeria. I'll be happy to hear what that policy is. The policy as published by the National Judicial Council does not fully emphasize the core of jurisprudential doctrine to be followed by judicial officers in the dispensation of justice. I think judicial officers have been left to individual whims and caprices long enough. After all, there must be certainty in the law. Professor Odita may react to this. Prof, please.
Thank you very much. I share the skepticism of Justice Ogunwumiju about the most appropriate labels to put, whether this is literal rule, golden rule, mischief, purposive rule. But for me, the starting point is to look at the intention of a legislature or the intention of a rule, and to ask what is the duty imposed on the court by this rule. The focus should not be on the power of a court. It should be on the duty of a court, because from duty, one can reach a sensible conclusion, whereas by asking what is the power of a court, and especially the approach of Nigerian courts and their penchant for taking refuge in catchphrases and box ticking as opposed to analysis, one is likely to be misled. So if you ask yourself, what is the intention of the legislature? What is the purpose of this rule? What duty does this rule impose on the court in this circumstance? You are more likely to adopt an approach which reflects the substance and justice of the situation rather than form. Of course, this assumes that the judges are acting with purpose, competently, and with integrity, because as Yemi Kandi Johnson pointed out, often corrupt and incompetent judges can take refuge in technical justice, in technicalities, rather than in substantive justice, enriching outcomes. And I've seen this many times, Nigerian jurisprudence criticized on the basis that these rules, these technical approaches are intentional, and they are simply there to disguise corruption by judges. In fact, the Nigerian government has faced this difficulty in resisting the attempt by a number of international oil companies to enforce large awards in the Southern District of New York, in some of which I have provided expert opinion, trying to assist those courts to understand what is actually happening in Nigeria. But it seems to me that the biggest problem that the modern justice administration has is the taking refuge in formulas. The most the most serious of these formulas is probably the case called Madukolu and Nkemdilim. It has done untoward damage to adjudication in Nigeria because it's simply a formula. It's a catchphrase. You ask yourself, according to Bayramian in Madukolu, a court is competent if these three things are present. And so you begin to apply those things as if they're a formula. Once you apply them, you tick the box, then you set aside whatever is before you, irrespective of whether that serves the public purpose, whether it serves the intention of the rule, whether it serves the intention of the public, whether it serves the intention of the legislature, and so on. But that's why I often say that the recourse to formula is an abdication of analysis. And I can give you another example. We're very fond in this country of citing Lord Denning in UAC and McFoy. And I don't remember many English lawyers or judges even citing it today. But in Nigeria, we're very fond of that case. You cannot place something on nothing. That's another example of a catchphrase or a formula. It obscures analysis. It doesn't tell you very much. If, for example, a thief came into my house and stole my money, clearly title to that money will not pass to the thief. But if the thief goes to a shop and purchases grocery, title to my money will pass to the shopkeeper, and the thief will acquire the grocery. And that is a classic, very straightforward, everyday example of something being placed on nothing. So it is not correct to say something cannot be placed on nothing. The correct inquiry is to find out the situations where indeed something can be placed on nothing. But the taking refuge in a catchphrase or box ticking, you cannot place something on nothing, does not really allow one to analyze the issues, to understand how this might apply, and the numerous circumstances where it has no application. So I would say that it's not really about finding a label to it's not finding a label to describe the correct approach, because I'm skeptical about labels. As soon as you invent a label, the courts will again take refuge in that label instead of trying to grapple with the underlying issues, the substantive issues, and therefore trying to avoid the perversion of justice. We all know, of course, that when I refer to predictability of outcomes, that the real bane, or one of the real difficulties in Nigeria, is the inability to predict the outcome of judicial decisions. Whereas the strength of English law today, as developed and applied, is the ability to predict with a reasonable degree of certainty the outcome of judicial decisions. How do you tell someone, these are your rights, this is how the courts are likely to approach this issue when you go to court? In Nigeria, you don't know, because we've seen some of the lotteries with litigation, especially constitutional litigation, election petitions, and even routine ordinary criminal litigation. So justice is being perverted, and often by recourse to technical rules. Even if one is looking at the Constitution, there are so many ways you can ask. You could ask yourself, are you looking at the intention of a lawmaker at the time they made the law? Are you looking at the intention of a lawmaker today? Are you looking at what reasonable people would construe that provision as when it was made or today? So there are many different approaches to looking at legislative intention. If you have a document which is intended to be eternal, like a constitution, why would you interpret it in a manner which a modern progressive judge won't interpret a commercial agreement? So many of these difficulties are self-imposed difficulties, and the solution must lie with the judges. For example, the difficulties arising from jurisdiction or misuse of jurisdictional object is entirely judge-made, entirely from A to Z. And they must rescue themselves because they have put the adjudication, they brought adjudication into disrepute by reference to judge-made rules which serve no purpose at all and merely cloak incompetence and often corruption.
Thank you very much, Prof. I think Bree is still on. Just a quick question before Mrs. Bomalabi comes on. Bree, are you there?
I am. I'm here.
Okay, so a few questions. You had mentioned that the Queen of England that makes the appointment of justices. So first question is this: can the Queen refuse a recommendation from the Judicial Appointments Committee? One, if the Queen could refuse an appointment, on what basis and on the advice of who? Next question is, you spoke of diversity as a consideration for the appointment of judges. Now, what role does this play as it relates to merit? Do you put both on an equal pedestal, or will you rank merit over and above diversity? Because of course we have something similar to diversity locally. We call it federal character. The last one is this, or well, the last two are these. You also spoke of advertising as a means of getting candidates for judicial appointments. Do you invite suitable persons as well, rather than just rely on people that respond to adverts? And lastly, when there are appearances before the panel that decides on appointments, are these appearances made public to the entire world to see? Thanks, Bree. And after you, Bomalabi will come on.
Okay, in terms of the Queen, I'm not a constitutional lawyer. The appointment of judges before the 2005 Act was a matter of our unwritten constitution. The Act provided for the establishment of the JAC, the request to come from the Lord Chancellor. It doesn't actually refer to the Queen at all. So as a matter of practice, our recommendations go to the Lord Chancellor and then they're passed to the Queen. There has never been a refusal of one. And I suspect a constitutional lawyer would tell you that if the Queen tried to refuse, we'd have a constitutional crisis. And the courts would have to work out if she actually had the power to do that. It certainly never happened. And the legislation that created the JAC doesn't provide for that, doesn't contemplate that, doesn't show her as having a role at all, but as a matter of the sort of historic common law position, all judges are her judges, dispensing the Queen's justice. So it does have to come from her. So I don't know if that answers. I think the simple answer is probably no one contemplates she has the power to do it. It'd be interesting if she tried, but disastrous. In terms of diversity, our obligation is to appoint on the basis people of good character on the basis solely of merit. So once people have applied and are going through the process, we can assess and evaluate merit and merit alone. If we get to a point where, given the number of vacancies we're looking to fill, the point at which we would fill them has a collection of people that are of equal merit, then at that point we can ask the question as a commission as to what their characteristics are vis-a-vis areas that are unrepresented for that role, and we will prefer a candidate. So the reality is that that happens where there are large competitions, either at the shortlisting process stage or at the final decision stage. You may have a number of candidates who on merit have been ranked identically, and then we would prefer or appoint those who, if a particular role is lacking in terms of people of colour, or in terms of women, or in terms of solicitors as against barristers, then we will prefer the people that have those characteristics and appoint them, and not the white male barrister. So I hope that explains. So it's merit and merit alone. Diversity just comes in when you've got people of the same standard. But before that, we do a lot of work to encourage applications from people from underrepresented groups, a lot of work with our stakeholders to give support and encouragement and help to learn how the process works in order for people to be prepared to apply. But once they're in the application system, everyone's assessed on merit, and that is the lead, and diversity doesn't get mixed in with it, if I can put it that way. In terms of advertising and inviting, we obviously encourage constantly people to talent spot in the most informal way. So we do a lot of outreach with different groups, with specialist bar associations, with solicitors groups, with other places that we think there may be applicants and applicants who don't think in terms of a judicial career. We do a lot of going out talking. We do a lot of encouraging others to, when they see someone who they think is talented and would be a good judge, to actually encourage and support them. We do not at the moment, and I don't know whether we will, do any targeted recruitment by JAC itself, but we do constantly ask people in the system to look and think widely about who might make a good judge, and to encourage people to engage and to give them information. And as I say, we do a lot of outreach work ourselves that's designed to do that, but not in a targeting individuals, more targeting places and groups where talented individuals may be. In terms of the selection days with the panels, those aren't public. So that's a simple question. They have the same structure. The structure is transparent, but the actual event on the day is not. But as I said, there's commissioner oversight. So in a small competition, say we were recruiting 2 or 3 people, one panel, dealing over several days, I would probably sit in on 2 or 3 of the interviews, and someone else from the secretariat would sit in on the rest. There is always someone there as an observer, either a commissioner or someone from the senior JAC staff.
Thank you very much.
Have I covered everything?
Absolutely, yes, you have.
Lovely, thanks.
So we're actually preparing to round up. Mrs. Boma Alabi would come on. I was at a panel, a webinar recently organized by the Rivers State Judiciary, where Mrs. Boma Alabi also participated, and I you are called Sister Bombs.
I am Sister Bombs. Hi, Bode. Thank you for having me. Thank you for organizing this as well. It's absolutely fantastic. Greetings to His Excellency, our Vice President, and our gift from this profession to Nigeria, Professor S.A.N. Yemi Oshibajo. Greetings to Professor QC S.A.N. Odita. Of course, Yemi Kandi Johnson, S.A.N. And if leaders here listening, that's Wale Oladipeku himself, S.A.N. as well, greetings to you. And of course, to Bree and all the panelists. Much of what I would have liked to say and actually agree with has been said by Professor Dieter, and far more brilliantly than I ever could. So I totally just aligned myself with his entire presentation. I think the only value I can add to this discussion is to go to the housekeeping aspect of things that can immediately improve things if we make some changes in those areas. So for instance, Prof was talking about, the Supreme Court turning barristers and litigating counsel into the registry, asking the question where, when did you file this? And have you filed that? The reality is the judges are not in control of the registry, and that has to change in order for us to get the value and the quality of service that we expect from them. You can have the most brilliant judge in a court, but if the registry staff are, not qualified and not organized, it's a complete shambles. And the poor chap who's, the face of the court and the person we blame has no choice and just sits there helplessly whilst the registry is entirely disorganized, and it then reflects on the judge and his delivery. Who appoints these registry staff? That's the question. They're civil servants. And I call them evil servants because most of them are there not on merit, not because they're qualified to do the job. It's because they know somebody who knows somebody who knows somebody. And how does the judge have the authority to discipline the registry staff when they don't meet his standards? And so on. So we need to look at the support system and how to make it more efficient, ensure that they have control of the stuff that's supposedly put together. Consider, again, it's for the
I think Bomala Biz Network is actually bad. So we're going to take and Professor Otomi, they will give us the closing, the final comments. But I'll just, and in giving us those, in bringing this event, in closing, there's a comment from one of the past participants, Oranugo, and the question is this. I mean, Chinyere had reviewed everything and asked this question: what next? What next? So would want closing remarks from everyone and ask, to just let's take a decision on what the next steps are. In doing that, I also want to pose very specific questions to Professor Fidelis Odita, SAN, and Mr. Candide Johnson, SAN, if Mr. Candide Johnson is still on. I can see Professor Odita. These two comments are from two of our respected judges, my Lord Justice Adeni Ikoka and my Lord Justice Abiodun Akinyemi, Justice Adeni Ikoka of the Lagos State High Court, Justice Abiodun Akinyemi of the Ogun State High Court. And this is what Justice Koka has said. In a personal estate matter in which I act as executor, an SAN wrote directly to non-parties, occupants in the subject matter to threaten them, notwithstanding that they are not parties to the suit. And the SAN is very much aware that we are represented by them. With whom should he be communicating? One, my Lord Justice Akinyemi, he says, it is obvious that all segments in the judicial sector are complicit. However, the most corruptive influence in justice dispensation are senior lawyers. What is the bar doing about this? While it is not an excuse to be corrupt, welfare of judicial officers must be constantly reviewed if the best must be attracted. Merit, merit, merit. Otherwise, we haven't started. Now, there's a strong focus here on the conduct of very senior lawyers. And I mean, Leonard Silk, Professor Odita, you would know, I mean, you will see situations where, in fact, senior lawyers go, for example, Mr. Candide Johnson gave that example. Very senior lawyers go to judges with ex parte applications, ask that the accounts of companies be frozen. Ex parte applications. So you go, you get the accounts of companies frozen, salaries cannot be paid, statutory obligations in the forms of taxes and all of those cannot be paid, cannot be met. Now, should there, whilst we agree that it's not everything that a senior lawyer takes to court that a judge should agree with, should we also not beam the searchlight on senior lawyers? Professor Odita, we'll start with you, and those will also be your closing comments with the question from Chinyere Oranugo asking what next. Professor Odita, 2 minutes, please.
Sorry, I agree that a senior lawyer should be sanctioned. Really, there is no excuse for bad behavior, but a lot of senior lawyers act with impunity, and that's in part because of a completely ineffective system of
I've been streaming on the laptop, the device, yeah, okay.
Sorry, should I start again? What's the problem?
Prof, please go ahead. Please go ahead.
Yes, I was saying that the behavior of some senior lawyers, in fact, many senior lawyers, is totally to be abhorred and to be condemned. But they act with impunity, largely because of the ineffective of a system of self-regulation, which is operated by the Nigerian Bar Association. It is a matter of common knowledge that most petitions which were filed with the Legal Practitioners Disciplinary Committee in the last 2 years have not been heard. Whereas in contrast, most effective complaint procedures would have resolved many complaints within 2 to 3 months or 6 months at best. So a situation where for 2 years there has been no hearing of complaints, it encourages these senior lawyers to be very badly behaved, and a number of them are very badly behaved. A number of them have no integrity. I think Yemi Candide Johnson gave a few examples of some who have been sanctioned, but the reasons why those people have been sanctioned are more pervasive. I mean, Senior lawyers bribe all the time. They try to pull their weight, they throw their weight around improperly. But also, one must say that the judges themselves are to blame, because one of the things I mentioned is that the judge must try and insulate himself or herself from political, economic, and social pressures. If someone comes to you with an inappropriate ex parte application to freeze a company's account, for the sake of crying out loud, you're not a baby. Why should you grant the order? Whether or not it is opposed, you ought to exercise your own common sense and discretion to know that the application made before you is entirely inappropriate. So I don't think that a person who is a decision maker should pass the buck to an advocate who is merely presenting a case, whilst the advocate retains responsibility and should be sanctioned for acting contrary to ethical standards. There is really no excuse for judges who accede or cave into such pressures. In relation to what can be done, a lot can be done. As the Vice President pointed out, there are real problems. The problems have been accumulating for a number of years, but we must start by broadening the recruitment base. For example, I noticed that in June this year, my very good friend, Professor Andrew Burrows, who is a professor or was a professor at Oxford University, was elevated from the university to the UK Supreme Court. And yet, in Nigeria, we hear Chief Justice Tanko Mohammed saying that he's not going to get anyone to the court who has not gone, he's not going to take judges from the bar or from the academia unless they have gone through the magistracy and then ended up in the Supreme Court. But surely that cannot be right. And that type of thinking must be changed very quickly if we're to make any progress at all. Unfortunately, some of our very senior judges are extremely weak, and one has to say it. It's a case of very weak people at the top dumping down on everyone else. I mean, when have you ever seen turkeys voting for Christmas? So those judges are afraid of their own shadow. They're afraid of everyone, and they don't want people who they think are going to be competitive to sit along with them. But the system is not for them. The system belongs to us all, and we must keep pushing and ensure that these reforms are made. Thank you.
Thank you very much, Prof. So the sequence would have closing comments from Bree, would have from Mr. Candid Johnson, SAN, would also respond to the issues I posed to Professor Odita. Then Professor Patutomi would give us his remarks, and of course, would have Chief Oliola Nipekon give us some remarks, and we'll call it a day. Bree, please go ahead. 2 minutes. Thank you.
I'm not sure it's really my place to close in relation to most of what's been discussed. I found it really interesting and really encouraging that you, as members of your legal profession and judiciary, are showing the bravery and the honesty to have self-reflection and challenge yourselves in terms of improving the system. I think that's something we all have to do. To go back to the early remarks about there being no such thing as a perfect system, but they can always be better than wherever they are. And certainly if there is anything else in terms of information and experience and sharing of that the JAC can do from the UK, just let us know.
Thank you very much, Bree. We've got a lot of requests for your presentation, your slides, and I've given assurances that we'll share that document because it's very detailed and it's going to be very helpful in taking decisions. Mr. Candid Johnson, your further candid views again.
Thank you very much. You know, I just say something quickly about this question about senior lawyers. You know, a lot of people think that seniority at the bar is a license to print money. This is a mistake. Seniority at the bar, especially the rank of senior advocate, is a mantle of leadership. And it is one that should be borne with the greatest sense of responsibility and the greatest caution. I think that it cannot be oversaid that a failure of ethics, a failure of proper behavior from a senior counsel is a matter that should be treated with the utmost sense of seriousness, and that what a junior lawyer would get away with should bring down the career of a senior lawyer crashing around his head. And that is the way you create examples. It is very important to show examples in any form of leadership. And I think that this idea, which is quite rampant, that senior lawyers consider themselves above the law and they exhibit the most reckless and irresponsible and often illegal behavior, is something that has to be smashed. As to the future, I think that at some point in the beginning of this government, when I think this government was still talking about change, I heard that they were considering an inquisition into the judiciary and setting up some sort of commission. You know, there's so much really that can be done. I think that the question of improving the welfare of judges is very important, but I would not improve the welfare of judges who are not performing at an optimal professional and ethical level. And I think you can use the lead of improvement of services as a basis for a structural, fundamental rearrangement of the way that judging works and the way that judges administer their function, the way that lawyers operate in that context, and that inevitably that process would require you confronting a few clearly incompetent and corrupt judges with their life history and persuading them to find something else to do with their time. Thank you.
Thank you once again, Mr. Candy Johnson. Professor Patutomi, please.
Thank you so very much. Again, my apologies that 3 different devices failed at the same time. But I was going to make a quick point about one, legitimacy of the entire judicial system, of the essence of lawyers, rests on the ethics of the profession and how people hold up and stand up for these. I mean, think of the US presidential elections. Dan Quayle, not Dan Quayle, Bill Clinton's vice president, who won the majority votes, could have gone to court and litigated to Al Gore till forever. But he looked at the legitimacy of the whole system and thought that it was best for him to sacrifice that run. I mean, you see that happen again and again. I think that any senior lawyer or judge who does not realize that their action actually carries the weight of the entire system, I think is not fit to be in that position. I think we must think in those terms rather than our immediate short-term interest. If the system is going to work for everybody, if the institutions that are going to ensure that this society thrives will be in place. I think that bearing that same in mind, that there should be perhaps cleansing quiet councils that include not just lawyers, but even some respected non-lawyers that do a systems review or audit from time to time, looks at the track that the whole system is going and gives quiet recommendations to the players about what's not going right here and the consequence for the entire system. I think that if we can manage to begin to do those kinds of things and even let the world know that the kind of introspection that is going on this platform is taking place, because the honest truth, as someone who consumes what the judicial system is offering, is that most Nigerians have given up on the justice system. Most Nigerians think that, you know, if you're going back into time, the whole idea of Frederick Bastiat of legal plunder, that this has just been taken to the extreme with the support of a compliant judicial system and lawyers just working for their pockets and not caring for the system. I think that there needs to be an effort by lawyers, the bar, to consciously rebuild the legitimacy of the system by getting to ordinary people to say, look, we are cleansing from within. We recognize that we need to do things differently. Once enough of that is done, you will see new trust for the system. You will see its effectiveness as an institution that places boundaries that people can trust. You will see better investments in the economy when these kinds of decisions are made, where kind of thinking judges recognize that it's not about procedure, it's about how the system moves forward. I think we'll profit a great deal from it. And I'm extremely excited to listen to Professor Dita, Mr. Candid Johnson, and many of the contributors to this program, because it gives me a lot of hope that the system can work if we have this kind of commitment of active participants in the system, and the system does need it.
Thank you very much, Prof, about making these conversations public. Aside the pre-registered participants, the event is also beaming live on YouTube, so that there are quite a couple of people watching the conversations live on that platform. So, final comments from the founding partner of Wole Olanipekun & Co., Chief Wole Olanipekun SAN, started the business 40 years ago, 1980. We're a 40-year-old business this year, and we've been active participants in the justice sector delivery, since then. Vision of one person that we're still pushing and trying to improve on. Is someone I'm always proud to call my brother Silk. Chief Wole Olanipekun SAN, please.
Thank you, buddy. May I appreciate every one of us who has participated on this very, very important meeting aimed at rejigging, at reorganizing, at repositioning the justice sector arm of government, the third arm of government, to which both the judges and the lawyers subscribe. It's been very God has beckoned to mount the superior bench has descended to a very sorry pass. And let me openly confess and also apologize that wittingly or unwittingly, people like us have contributed to it. And how did I? Once upon a time, or not once, not twice, when some decisions were to be taken against judges, when the security agencies bombarded the houses and homes and residence of judges overnight, I championed the cause of condemning them. And then my brother Yemi will also bear testimony to this. Remember that meeting we had in Abuja overnight when the immediate past Chief Justice was removed, how we brainstormed on what we should do. Now, Shakespeare said that the fault is not in our stars, but in ourselves. A lot of things a spade, an instrument, an agricultural instrument. A spade remains a spade. We have a system in our hands in this country today where we have judgments without justice, period. And how do we correct that? We also have a situation whereby at the appellate courts, you no longer have dissenting judgments. Thank you, my brother Udita. Parrot, Lord Denny, when an action is void, you can't put something on nothing. The same Lord Denny said in Packer and Packer that you don't say that something has never been done before as a result of which you don't want to countenance it. You don't want to sniff it. Otherwise, the entire world will pass you by. We forget the position of Lord Denny. What happened? What excited him to make that statement then? Then we have situations now in the country whereby you go to, your clients come to you. The first thing a client asks a lawyer, advise me in writing, give a legal opinion. You can no longer give a legal opinion because you have conflicting decisions of appellate courts. I presented a paper at a function in years back where I did a surgical presentation on conflicting judgments of appellate courts. A justice of the Supreme Court, name withheld, who sat next to me said, "Are you sure that I gave him all the things?" Now, you also have a situation whereby your clients even come to you and say they know the law more than you, quote and unquote. So where do we go from there? And we also have a situation whereby it's only in Nigeria. It's only in Nigeria that I know, the little research that I've done will bear this out. It's only in Nigeria that we know that judges of the appellate courts are appointed based on promotion. It's not done here in Ghana. It's not done there in Kenya. It's not done in the UK. It's not done in America. It's only here also in Nigeria that we know that when you cite decisions of appellate courts that are binding on them, nobody cares to listen, nobody cares to watch, nobody cares to read. And matters are decided one way or the other. We just have to rejig, we have to resituate the profession. It belongs to all of us. And this type of seminar, this type of interface, this type of conference should be encouraged from time to time. And I want to believe that the major participants, the operators, are revered judges of the Supreme Court, the Court of Appeal, and the High Court. They are participating. And I want to make this suggestion. You know, the time has come whereby we have to do something about ex parte applications. Otherwise, ex parte applications will do something about us. Most humbly, I was one of those called upon by the late Justice Tunde Begore to tinker about the utility or otherwise of ex parte applications. Otherwise, and as provided by tradition, maybe judicial review of administrative actions, mandamus, statutory, and what have you. Then that was why we suggested that ex parte applications will lapse at so period, a time, gestation period defined. But then despite that, we have it now, ex parte application rampaging. It's become a rampage here and there. Every day, senior lawyers go to court, and with all respect to some of our colleagues, we should not agree that judges, they hold the eyes, but there are things that we should not also place before them. And lastly, about what Bowman said on registry of court, which was alluded to by Odita. Bowman, are we trying to defend? I don't know. You are saying that the registrars were appointed, but you said they are civil servants. No. Let us get the point clearly. They are officers of the judiciary. They are appointees of the Judicial Service Commission, whether at the state level, at the Court of Appeal level, or at the Supreme Court level. And let us begin to tinker, to wonder. If at a point in time you get to the Supreme Court, you get to the Court of Appeal, you get to the High Court, and the judge hasn't seen the process, and the registrar brings out the process, it will seem not better that the matter be adjourned, because a judge must first of all clear his file. He must be a master of the record. He must be a master of the facts. A judge who is just seeing the process for the first time in the morning, being thrown at him by the registrar, who has brought it from an obscure corner of the file. Then how would the judge, align himself with the submissions of the counsel? All said and done, it's been a very exciting period. I want to appreciate each and every one of you. And please, please, and please, we must put our heads together. And let us, all of us, be sober. Nobody is a superhuman being. It's only God that is superhuman. It's only God that is supernatural. Let us appreciate the fact that where my wisdom ends, that's where that of Candy Johnson begins. And where that of Candy Johnson ends, that of Odita, begins there, and so on and so forth. So don't let anybody say that, because I'm on the bench, or because I'm senior advocate, I'm more superior than others. Let us be humble. And let us be humble and sober enough to appreciate that that the time is right for all of us now to put our heads together to join hands at rejigging our profession. We are not in the best of times. May God bless each and every one of you. And may God bless the Nigerian legal profession. And may God bless the Nigerian judiciary. May God bless the Nigerian nation. Thank you.
Thank you very much, Chief Olanipekun. I think with all the comments now, I actually don't need to explain why we put up this summit. It's going to be, by the grace of God, a yearly thing going forward. It's looked like quite a number of people have come down very hard on judges and very senior lawyers, but the truth is that's the way it is. And I would like to refer and read out a comment of a Supreme Court Justice designate, my noble Lord Justice Ogunwumiju. She just put up a comment, and we respect Justice Ogunwumiju for our very radical views. You know, Brie has told us that the Queen has never rejected a nomination from the JSC. So this is what my Lord Justice Ogunwumiju said on the platform, on the discussion platform at 2:17 p.m., roughly about 10 minutes ago. She said this: I feel very strongly, and I tell my colleagues often, that hardly do litigants enjoy going through the judicial process in Nigeria. That is this is coming from someone that has been a practicing lawyer. She was a judge of the High Court. She's a justice of the Court of Appeal now, a presiding justice of the Court of Appeal, and now a Supreme Court justice designate. She said this, that and this was our closing remark, or these were our closing remarks, that the expensive, painful, and long process is laid solely at the feet of judges. I need not add more. My Lord, we thank you very much, and we pray that the tribe of justices like you on the bench will continue to soar. I wish everyone a very pleasant weekend, and the communique from this summit will be released very shortly. Thank you, and God bless.